a suit for examination. My witness is to, I'm the plaintiff, he's to come into the box. I'm not praying for any accommodation, just indicating, my lord, that he's in China. We discovered he's in China. So he won't be able to come, so that my lord's time is not wasted. My lord, I'll come and make the prayer tomorrow, my lord.
My lord, may I be permitted to mention one probate matter? Here in this matter, only one class 1 legal heir has given consent to the proceeding for inclusion, my lord.
Your Lordship, may I permitted to mentioning for inclusion, Your Lordship. Notice is already served, Your Lordship. Notice is already served, your other side. The matter issued for recovery.
May I be permitted to mention one basis of administration matter for inclusion in your lordship's list?
My lord, for inclusion, this is an appellate side matter, CRR matter.
What?
CRR.
CRR? Which?
My lord, 2024.
No, it is not assigned matter. This court is only taking the assigned matter.
My lord, is the matter
Within
was
that 200
yes,
matters,
yes,
you
my
are,
lord.
so why you are mentioning?
My lord, the matter was not appearing the last Thursday.
No.
It was appearing before that.
All matters.
My lord,
All matters listed,
my lord,
sir.
my lord, it was 27th of
Which
February.
serial number?
It was appearing.
Okay, you give the list to my court officer. He will check if it is in the serial number. Automatically,
Yes,
it will. If it is in that group of the cases, then it will.
It is in that matter.
Your Lordship was pleased to direct, allow me to clear the defects as given by the master. There has been 1 day's delay, so I was seeking an extension.
1 day delay for?
Clearing the defects, Your Lordship.
Hmm.
An affidavit had to be filed, corrected affidavit, that was affirmed after 1 day.
Where is the order?
Your Lordship, I'll give it over to the court officer in due
Comes
course.
tomorrow with the order, we'll see to it.
May I have my Lordship leave to mention? My Lord, item 17 of today's list is fixed at 12 p.m. Unfortunately, the leading counsel is unavailable.
Non-commercial?
Testamentary.
Commercial matter, non-commercial matter. Item number?
17.
Of which matter?
It's a
Commercial or non-commercial?
testamentary matter. Fixed at 12 p.m. At 2 p.m. Sorry.
Sponsor.
My lord, I'm opposing that.
Huh?
My lord, I'm opposing that.
Item number 15 of? Non-commercial, yes.
My lord, my witness was being cross-examined. My lord had fixed on 16th of January after my lord getting a busy schedule of my lord's diary. This was fixed today. My witness has come down today morning from Rourkela, keeping aside his medical treatment. And my lord, yesterday evening at 8 o'clock, they are so busy for 2 months, they could not intimate. Kindly don't adjourn it, my lord. He has come down from Rourkela.
My Lord,
Fixed today.
It's fixed today at 2 p.m.
Fixed today, come at 2.
The counsel is not.
My lord, this is
Maybe that it is your risk. If the fixed matter, all bar
has taken the
members
pain to
knows.
come down from
what-
Rourkela today
If
morning.
it is not mentioned in advance, it is very difficult to get it adjourned. If
I'm
it
opposing
adjourned,
it,
then
my lord.
you know what would be the consequences of adjournment. That is the two things. Either you get it ready, or if you want to continue with the adjournment, then consequences will
My lord,
follow.
This had been
the
the
other-
same.
other-
next week. Next week, my Lord, it will surely be.
He is not in Malad. He has come down from Rourkela today morning.
Let
Lord,
come at
the
2,
leading
come at
counsel is
2,
not-
come at 2. Yes. Call the
My
list.
lord, may I be permitted to mention one matter for inclusion in the list, my lord?
Why-
My
for
lord,
what?
one civil suit matter, my lord, already presentation of the form has been done and summon has been served, my lord, for inclusion in the heading of motion, my lord.
Have you filed any interim application? For what?
No, my lord.
What application you want to move?
My lord, I want to move, fix for hearing my civil suit, my lord, for recovery of the money, my lord.
That's correct, madam. Your civil suit plaint has been presented. It is admitted. Have you filed any interrogatory application?
No, my lord.
Why you want to include, mention the matter to include in the list?
Because, my lord, till date, the
Scrutiny.
defendant has not filed any WS, my lord. And
When the writ of summons is served, have you
my
obtained
lord, in the year
the
2023,
have you obtained report?
my
Have you
lord.
you are having the report that the writ of summons was served and the written statement is not filed? Have
My
you
lord.
obtained report?
My
You have
lord.
obtained report?
My
Give the
lord.
number to be mentioned, मेरे को.
Yes. Grateful, my lord.
What is the case? Who is,
My
any
lord,
junior
my
is here?
junior is handing over.
No.
She's standing and she's handing over, my lord.
Yes.
Grateful, my lord.
My lord, may I lordships kindly
Grateful.
to mention, my lord, my written statement, my lord. I am praying for leave to file written statement. My lord.
When it was received? Writ of summons was received. When you received writ of
It
summons?
was received on or about 21st November, my lord.
November. Now
my
we are
lord,
on March.
yes.
120 days is over.
No, my lord.
When it is going to be over?
It is at least we have time till tomorrow, my lord.
Till tomorrow.
I have also filed application for extension, my lord. Kindly give me leave to accept the writ extension. Subject to acceptance, my lord. File the writ.
Affirmed.
Yes, my lord. Everything is done.
Leave is granted to file in the department in course of the day, subject to acceptance.
Well, right. Item number 49 of your lordship's non-commercial list. Well, this is that Eastern India Motion Pictures Association. Well, we had challenged the election and the electoral role in this association. Well, it's a company. Under
49.
Item 49 of the non-commercial list. Well,
For the defendant, my lord.
yes.
Not
Well,
to written, they have to just mention the matter to be upgraded.
yes.
But your lordship are pleased to just say what's the list.
My lord, the reason why.
Let the list come up.
My lord, in last week it was appearing as item number 27. Now it has, my lord, come down to item 49. My lord, the difficulty is judge's brief is ready. All the, my lord, procedures have been completed. Now, my lord, the trial has to commence. We'll be praying for, my lord, appointment of a commissioner so that speedy trial can be done, my lord. The election of this company has to be conducted under the Companies Act, my lord, after March 31st. Once they, my lord, the accounts are ready, then before September they have to hold the election. My lord, if there is delay, then, my lord, the entire suit will become infructuous because, my lord, the electoral roll has to be prepared. We have challenged the electoral roll.
So what is the stage of the
My
suit?
lord, the inspection, discovery, everything is complete. Judge's brief of documents is ready.
Issue not framed.
No, my lord, yes, my lord. Issue is also framed. Everything is done, my lord. Now only, my lord, the witness action has to
When
come.
the issue was framed, whether the case is not fixed for the witness action?
No, my lord. At
Why?
that time it was not, my lord. I have the order
When
with me.
the order was passed for issuance for framing of issues? By which order? Issue was framed?
It was, my lord, sorry, my lord, I'm not carrying right now. My lord, it was, my lord,
January 22nd, my lord.
This year?
yes, my lord.
By this court?
Yes, my lord. By your lordships.
If the issue framed, why the date is not?
22nd of January 2025.
Have you filed the judge's brief of document?
We have it ready, my lord.
So that's why the case is fixed for order.
We have served it upon the other side already, my lord.
Have you served?
Yes, my lord. They have gone through it and they have accepted.
काम करो कल कल पहुंच रहा हूँ. Yes, it will be listed tomorrow as for orders.
So grateful, so grateful.
Yes, call.
Obliged.
So this court is held with regard to the prima facie and all these things, but with regard to the commercial, this court is held that it is a commercial dispute. So print is written, we but you to file a fresh before that.
I'm deeply obliged. Can I read the order?
Instead of PLA, instead of PLA, testament.
Okay. Suit number should be disclosed.
Oh, that's why. The matter is listed as to be mentioned on receipt of the report from the office of the master dated 11th of March 2025. By an order dated 21st of February 2025, this court has disposed of TS 8 of 2022. But in the third page, last line, this court has recorded PLA 324 of 2021 is disposed of instead of TS 8 of 2022. Accordingly, in the order dated 21st of February 2025 at page number 3, last line, instead of PLA 324 of 2021 shall be read as TS 8 of 2022 is disposed of. This order may be incorporated with the Order dated 21st of February 20. Already discussed. Incorporated with the order. Yes. Acha, that judgment. Who is not? Nobody is there. Not today. If anybody will come. Not today. Inform the advocate on record of inform.
This is that partition suit. I believe department is facing some difficulty in
Correct.
drawing up.
Correct. In this, prayer A.
Only Millard, the plaintiff share has been mentioned.
If it is a consent, then it is the share of the plaintiff and the defendant should.
Defendant plaintiff share is 1/3. That they have also agreed.
You're no 2/3.
1/3 in 123A Lelin Shoroni
Yes, 1/3 in the 123, and that is a prayer B, and prayer A 2/3.
and 2/3 in 76.
Correct. So with regard to the what is your share?
Lord, 1/3.
No. 76 says. 1/3 Millard, his 1/3 is in 26 Benting Street.
Yes.
1/3 each of the defendants. 2/3 is your,
That is
and 1/3 each of
the defendants, yes.
that is also a part of your
Part of
lawsuit
the না ওটা আমারটা বলা
and B 1/3 is your.
1/3 2/3 আমাদেরটা কত
So how their share will be? If it is your 1/3 of, then it is 1/3 each.
1/3 each of their part. 1/3 1/3.
No, B also 1/3 each. Plaintiff, defendant.
1/3 each to. B also 1/3 each.
1/3
Three brothers.
Benting Street.
তাই তো?
2/3 of the plaintiff and 1/3 each of the defendant.
Each.
1/3 each of the defendant.
Two-third is for plaintiff.
2/3 is.
If defendants are defendants jointly 1/3, then it will be 1/6.
Yes.
1/6. It would be
1/6.
1/6.
1/6 share. Thank you. 1/6 share each in the A. And 1/3 each in the
B.
in the B.
বুঝতে পেরেছিস?
1/3 each of the plaintiff and the defendants.
Yes.
In the B.
And in A 2/3 for me and 1/6 for them.
1/6 for them.
Yes, it's Millard will kindly see
Okay.
page 3 paragraph 4 of the plaint.
Plaint hai kya?
Yes. আমাদের কাছে আছে। It's little bit marked, Millard. It's marked. Paragraph 4.
Yes, 1/6 a undivided portion. So and so suffering for the plaintiff, so and so suffering for the defendants. The matter is listed as to be mentioned on receipt of the report from the office of the London Master dated 11th of March 2025. By an order dated 27th of January 2025, this court has
One second.
This court has passed an order for preliminary decree in terms of prayer A and prayer B of the plaint. Full stop. When prayer of the plaint, when the department has processed for drawing of the preliminary decree, that department found that in prayer A and B of the plaint, the plaintiff has only prayed for his share and no share of the defendants are mentioned, and as such the department is facing difficulties to draw up the preliminary decree in terms of the order passed. When the matter is taken up for hearing, the counsel for the parties submit that in prayer A of the plaint, the plaintiff is entitled to get 2/3 share and defendants are entitled to get 1/6 share each in the property situated at 76 Bentic Street P.S. Bobazar, Kolkata 77,001, 7 lakh 1. And in terms of prayer B, the plaintiff and the defendants are entitled to 1/3 share each over the property situated at 123 capital A, comma, Lenin Sarin, Kolkata 700013. Police. This order, the order dated 27 January 2025 is modified to the above extent, and this order may be incorporated with the order dated 27 January.
Now, my lord, one more thing. It was mentioned by both the parties yesterday.
Ah.
My lord, we then came to know that this is my lord pointed out. My lord, both the parties, my lord, this also the commission, my lord, the partition commission's view, my lord, a surveyor has to be appointed. My lord can appoint, my lord, it has to be.
The preliminary report.
Yes.
My lord. We have visited both the properties. My lord, one of the properties is completely encumbered. And
Completely
encumbered
encumbered.
by tenants, my lord, and both the parties, my lord, have with the defendants and the plaintiff have, my lord, submitted that they want to put that property on
For
sale
sale.
and to divide the shares.
Consent.
But that, my lord, order is not they have not intended that before, so that order may be passed, my lord. And for
Surveyor
that
or
also, my
valuer.
lord, valuation is required. And the other property, my lord, there is also certain disputes between the defendants and the plaintiff with regard to a boundary of 76 and 75. 76 is the subject matter of this suit. 75, the defendants claim to be a co-owner. Now his interest may be my lord, affected if the boundary is not demarcated. That's why there are some disputes.
So what you want?
My lord, a surveyor may
A
be
surveyor may be appointed, my lord. Consent of both.
ideally, perhaps, my lord, for demarcation, Amin is proper because surveyor may not know the government plans or the municipality plans.
Your Lordship may empower Mr. Shahu Miller to take necessary steps.
That is, I am giving a liberty to appoint a surveyor or
Amin or
whatever it is
whatever
for the
necessary.
proper adjudication
Yes,
of the
yes.
matter, proper partition of
Partition
the
of the
partition of the
And
property
only that, my lord, the cost may be shared equally
by the
equally,
both the
yes,
parties
yes.
in equal.
Three parties. Three parties
All three parties will be in equal share.
in
All
equal
three
share.
parties in
My
equal.
lord, his fees came around 66.6667.
That is possible through Google.
Yes, yes.
Google Pay is possible.
So full stop. Though the matter is listed today has to be mentioned on receipt of the report from the master of this court, office of the master of this court, but the partition commissioner appointed by this court has submitted a report and submit that one of the property that is
123
that is situated at that is the property situated at 123 capital A Lenin Sarin, Kolkata 700013 is full of encumbrances.
Yes, my lord.
Is full of encumbrances. All the tenants are illegal.
Tenants.
As
Paragraph
the,
12 onwards, my lord, I have indicated.
as the tenants are in occupation of the said premises. Said premises. Full stop. The concept and what about the other property? Full stop. As regard the other property,
Dispute with
there
regard to
is
the
a
boundary wall.
dispute with regard to the boundary wall in between survey number 75 and the plot number 75 and plot number
76 Benting Street.
of Benting Street.
And there are some structures which are in a dilapidated state, but I should not, my lord, make
Full
any
stop.
comments on
Full
that.
stop. The council for the partition commission submitted that it is not possible for him to ascertain the total value and to partition the said property unless a proper valuer and the surveyor is appointed. Full stop. Considering the submission made by the partition commission and considering the report submitted by the partition commission, comma, this court is given liberty to the partition commissioner for the purpose of partition of the suit property, comma, the partition commissioner is at liberty to appoint the valuer, appoint if require, appoint the valuer, comma, surveyor or Amin for affecting proper partition of the suit property in terms of the preliminary decree. It is made clear that if the partition commissioner is appointed has appointed valuer, comma, surveyor or Amin for partition of the said property, comma, the remuneration of the said said valuer, comma, partition valuer, comma, কি বলছি?
Surveyor and Amin.
Valuer, server, and Amin shall be paid by the plaintiff and the defendants in 3 equal share.
Okay.
Good. Take your print back. Next.
Where I appear on behalf of the petitioner, my lord, and this is my application for grant of probate.
Hmm.
My lord, on 21st of August, my lord, when this matter appeared before Justice Patnaik, my lord, and then paper publication and order was made. Thereafter, my lord, everything was done. I have received intimation from the department that there is no caveat. Now, my lord, when I see the case status, my lord, it is showing as case disposed of. At the next page. My lord, due to this, my lord, the matter is not being able to be listed.
So and so appearing for the petitioner. The matter is listed as to be mentioned on the prayer made by the counsel for the petition. Counsel for the petition submit that by an order dated 21st of August 2024, this court has allowed the prayer A and B of the PLA application and direct and was an order for returnable after 4 weeks from the date of affixation of the publication. Police counsel for the petition submitted in terms of the order passed by this court dated 21st of August 2024, comma, the petitioner has taken appropriate step for publication of the notice.
My lord, it is already published.
Publication of the notice and the notice were published. But the department is not in a position to take further steps, as in the case in the website of this court, the case status of the present PLA 391 of 2023.
389.
Registry, 389 of 2023 is been shown as disposed of. Considering the submission made by the counsel for the petitioner and perusing the case status in the website of this court, comma, the registrar, comma, IT is directed to take appropriate steps to take appropriate steps by deleting the word disposed of and to place the PLA 389 of 2023 as pending in the website of this court with regard to the status of the case in the website of this.
I am grateful.
Okay. Next.
My lord, in this matter, I am for the petitioner.
Yes.
My lord, on the last occasion, I had mentioned this matter, and your lordship was pleased to verbally direct me to file a supplementary affidavit.
For what?
My lord, the fact is that the testator in his will mentioned the name of the executor as Himanshu Tarafdar, and in the spelling of Tarafdar is Talukdar is Talukdar. But my lord, Hiranmoy Talukdar, his son, uses the surname as Der, which is appearing in all of his documents. So my lord, I have filed one affidavit stating the same that both are one and identical person. This is my supplementary affidavit. Will it be considered? And
where is the order? Disposed of?
It is disposed of.
By which order?
It was granted on 9th of 4th of September 2024.
In terms of that is the problem.
Alias, I can at the
What alias? Why I could not understand. Where is the PLA application?
Kindly come to my PLA application, my lord.
Yes.
My lord, see that
in the will.
In the will, my lord.
Yes. Where? Which page?
My lord, kindly come
the testator.
From the testator.
Himanshu Kumar Talukdar.
Talukdar.
TALUK.
Not with regard to the testator, my lord. With regard to the executor, my
Where
lord.
is the name of the executor?
My lord,
Which page?
at
in the
page,
will?
my lord,
Which page in the will, sir?
at page 3, my lord. Last
I
paragraph.
appoint Sri
Hiranmay
son Hiranmay Talukdar.
Talukdar. He is appearing as TALUKDAR.
TALUK Talukdar.
My lord, but Hiranmay Talukdar, his documents, in all of his documents, it is appearing as DER. That is the difference, my lord.
So what has happened?
The department is not issuing.
Very good.
I have filed an affidavit that both are same and identical person, my lord. We prepared the document on the basis of available records, and it is in his Aadhaar card and all of his documents, it is appearing as DER, my lord. How can I write AR, my lord?
The matrix recesses to be mentioned for correction in the order dated. For correction in the order dated
4th of September 2024.
Counsel for the petition. The counsel for the petition submitted by an order dated 4 September 2024. This court has granted probate of the last will and testament of the testator
Himanshu Kumar
Talukdar, dated 30th August 2013. 30 August 2013. Full stop. Counsel for the petition submitted. In the will, the testator has appointed his son, Sri Hirnamoy, Hiranmoy, Hirnamoy Talukdar, TALUKDAR, as executor of his last will and testament. And accordingly, the executor has filed the present application, and this court has granted probate. But at the time of issuance of probate, the department has pointed out that the name of the executor is Hirnamoy Talukdar, TALUKDER, instead of Hirnamoy Talukdar, DER. Thus, the department has not issued the probate, certificate of probate. Accordingly, counsel for the petition has filed a supplementary affidavit enclosing the affidavit and the document, showing that in all the documents, the name of the executor is appearing as Hirnamoy Talukdar, DER. DER. But in the will, inadvertently, the name of the executor has been recorded as Hirnamoy Talukdar, DER. Considering the submission made by the counsel for the petition and the supplementary affidavit filed by the executor, wherein he has categorically stated that, wherein the testator has, wherein the executor has also annexed the affidavit executed before the notary public, wherein he has categorically stated that the Hirnamoy Talukdar and Hirnamoy Talukdar is the name of one and the same person. Okay. Considering the above, the department is directed to issue the probate in the name of, issue the probate to the petitioner Hirnamoy Talukdar, the petitioner in the name of Hirnamoy Talukdar, DER. DER.
Yes, much of this one.
Okay. This order may be incorporated with the order dated 4th September
2024.
24.
Much obliged, my lord.
7. Yes.
My lord, I appear for the.
Just a minute. Yes.
I have filed, I appear for the plaintiff. I have filed this suit for damages for defamation and permanent injunction, my lord. The office report, the stamp reporter has taken a view that though for damages no court fees is payable, but for decree for injunction, court fees is payable. My lord, I am not so. This is payable because of prayer C in the plaint, which is permanent injunction, my lord. I am not pressing this prayer. I want to delete this prayer, my lord. This is my prayer, my lord.
Stamp reporter has submitted report data sensor in terms of the order data itna as per the said report, the plaintiff has to pay rupees 49,999 as court fee.
Because of prayer C in the plaint.
Decree for permanent injunction restraining the defendants for herself, his respective servants, agent, executor, holding any press conference or publishing, printing, calculating. Yes, and what about the A and B?
For damages, my lord, no court fee is payable, my lord. Here is a my lord, the court officer, the stamp reporter has also reported, and this is section 7, my lord, section 7(1) of the Court Fees Act.
Yes.
Kindly permit me to delete prayer C, my lord. 7, my lord, 1, provided that on the left side, my lord,
So you want to delete?
yes, my lord, I want prayer.
Counsel suffering for the plaintiff. Counsel for the plaintiff. Press for leave to delete prayer C in the plaint. Consider the submission made by the counsel for the plaintiff. The plaintiff is granted liberty to delete the prayer C of the plaint and within a week from date. Within a week.
Right.
Take your book.
My lord, this matter is appearing for presentation of plaint. My lord, this suit is for recovery of money lent and advance, my lord. My lord, the defendants are, though the defendants are outside the
Item
jurisdiction.
number?
8, my lord.
Yes.
This is a suit for recovery of money lent and advance, my lord. Though the defendants are outside the jurisdiction, but part cause of action has arisen within, my lord, which I pleaded in paragraph number 14. My lord, the agreement is within the jurisdiction, my lord, which is pleaded
Decree for 44 lakhs.
My lord.
So, where is the cause of action? Paragraph 2, 3, 4, 5.
My lord, paragraph number 14.
Plaintiff is within the jurisdiction of this honorable court. Building constructed and the different urgent requirement of the execution of hand. Plaintiff within.
My lord. My lord, I am seeking for clause 12 leave, my lord, to help this.
Stephen House, Kolkata within. Both within, then? What
defendant, my lord, the defendant is outside, my lord.
Where it is? Where you mention?
My lord, in the cause title, my lord.
Which paragraph? Which paragraph? Then you come with an application for amending the plaint for adding the paragraph.
My lord, if my lord takes up the cause title, my lord, all the defendants.
Cause title I seen, but where is the pleading? Then you will face difficulty in Order 7 Rule 11.
My lord.
Show me. I could not find. When you're drafting the plaint, first duty is with regard to the discretion of the plaintiff and the defendant is to be.
My lord.
Not mentioned.
My lord, in paragraph number 10, I have pleaded that the defendant number
Where
has
is
received.
where show me?
My lord, in paragraph number 10.
Hey.
My lord, 10. My lord, I have sent all the demand notices to the defendant's address, which are all outside the jurisdiction of this honorable court, my lord. In paragraph number 10, the penultimate sentence, my lord.
So suffering for the plaintiff. The plaintiff has filed the present suit praying for a decree for a sum of rupees 44,57,359, along with interest at the rate of 10% per annum. The counsel for the plaintiff submit that some cause of the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of the court, and part cause of action arose within the jurisdiction of the court and part cause of action outside the jurisdiction of the court. Accordingly, prays for leave under clause 12 of the latest petition. Consider the submission made by the counsel for the plaintiff. Plaintiff leave under clause 12 of the latest patent is granted. Plaintiff submitted subject to scrutiny.
Much appreciated.
Scrutiny by the department.
Your Lordship, this is
Yes.
Your Lordship, this is my suit praying for inter alia declaration that the plaintiffs are the absolute owners of the suit property. The suit property is within jurisdiction. We haven't sought for clause 12 leave or order to.
Why it has come here?
I don't know, Your Lordship.
Why it has come? Master. You mentioned direct 38, not master. It could have been sent to the master. So suffering for the plaintiff. It is found that the plaintiff has not prayed for any leave from this court. Accordingly, full stop. Let the plaintiff be placed before the master for appropriate order.
This is your lordship. This is my suit for eviction and mean profit, where the subject property is within jurisdiction, your lordship. Lordship would kindly take page 37 of the plaint.
Why order to rule 2, order to rule 3, order to rule 4?
Yes, your lordship. Order to rule 2 because there I could have additional reliefs which I could pray for. Order to rule 3 and 4 are coupled for joinder of causes of action, your lordship.
Why?
Your lordship kindly takes the defendant number 1 is my tenant, but the defendant number 2 is a trespasser inducted wrongfully by the defendant number 1. Therefore, joinder of causes of action, your lordship.
No. Defendant number?
Defendant number 1 was my tenant, your lordship. That lease has been terminated.
Correct.
In the meantime, my pleading is that he has wrongfully inducted a third party, that is defendant number 2.
Subletting.
At the property. So, joinder of causes of action, your lordship. Order to rule 3 and 4. Order to rule 4, the master has the power to grant the leave, but it has been coupled with order to rule 3 as well.
CPC no?
Kindly takes the CPC once. The relevant pleadings, your lordship, would be at paragraphs 76 and 75 of the plaint.
Yes. Where is that?
Your lordship would kindly take page 37, paragraphs 75 and 76. But prior to that, lordship would also take paragraph 73 and 74, where the cause of action and the jurisdiction paragraph is set out. And in paragraph 75, your lordship, I've said so that in order to avoid multiplicity of judicial proceedings, we have prayed for leave under order to rule 3 and 4.
So and suffering for the plaintiff. The plaintiff has filed a suit for eviction against the defendants and recovery of peaceful, vacant and cast possession of the suit premise. The plaintiff has also paid for main profit. The plaintiff, full stop. The counsel for the plaintiff prays for leave under Order 2, Rule 2, Rule 3 and Rule 4 of the Code of Civil Procedure. Consider the submission made by the counsel for the plaintiff for use the pleading. This court find that the petitioner has categorically stated that the defendants are wrongfully and illegally occupying the suit property despite of receipt of the notice dated 18th of July 2024 and 18th of January 2025. Considering the above, this court find that considering the above, under Order 2, Rule 3, 2, 3 and 4 of the CPC is granted. Plaintiff is admitted subject to scrutiny.
Lordship would kindly grant me one leave at page 28 of the plaint. I've mentioned at para 46, the annexure number has wrongly gone down as letter I. It should be letter M. Page 28, Your Lordship, of the plaint.
Paragraph I. True copy of the termination letter.
Yes, Your Lordship, it should be letter M and not letter I. Lordship would kindly grant me that liberty
Counsel
to
for
correct.
the plaintiff prays for leave to correction the annexer number annexer letter as M instead of I, M invert comma instead of I. Consider the submission made by the counsel for the petitioner. Leave is granted to the petitioner to correct the annexer letter as annexer M instead of annexer I.
I'm grateful.
As appearing in paragraph 46, page 28.
I'm grateful, Your
of the plaint.
But the matter has come as presentation of plaint, my lord, wherein I have prayed for a leave under clause 12. My lord, if I will not kindly come to the array of the plaintiff, my lord, lordship will find, my lord, that the plaintiffs are all within, my lord. The defendant number 1, 2 and 6 are within. Defendant number 3, 4, 5 are outside. And the registered office of the defendant number 6 is within. And my lord, the other office is outside, my lord. So far the cause of action is concerned, my lord, it is partly within. That is, my lord, pleaded in paragraph 8 and paragraph 10. Lordship will find at page 6 and page 7 respectively.
What is the suit for? Recovery?
Yes, my lord, recovered.
5396.
Yes, recovery of money lent and a non-commercial, that's all.
Defendant number 3 outside, 4 outside.
Yes, my defendant number 3, 4 and 5 outside the jurisdiction.
And 6 within.
But the 6 is within, the registered office is outside. Otherwise within.
When the cause of action arose, sir?
But the cause of action has been pleaded in paragraph 21. And my lord, if kindly come to paragraph 8 and paragraph 10, respectively, and page 7 and page 10, Lordship will find that the D issued a confirmation of account to P, which the P received is within jurisdiction. And further, the part payment was made. Thereafter, my lord, all entire balance payment was failed and neglected to made, which the part payment was made from the bank account of the defendant outside to the bank account of the plaintiff within.
When the last payment was made?
My lord, last payment, my lord, was made. But the last.
Because kindly come to 22.
Yes, my lord.
Limitation within the period of limitation since 15 to 16 and 16 to 17, they acknowledge they agree to pay the principal together with interest. Since the defendant acknowledged its debt liability, made the payment from time to lastly on 24.
Yes, my lord. Yes, my
lord. So offering for the plaintiff. The plaintiff has filed the present suit for praying for decree for a sum of rupees 53,96,712 along with interest at the rate of 24% per annum. Police counsel for the plaintiff submit that the plaintiffs and the defendant number 1 and 2 are within the jurisdiction of this court, but the defendant number 3 to 5 are outside the jurisdiction of this court. The plaintiff counsel for the plaintiff submit the defendant, the office of the registered office of the defendant number 6 is within jurisdiction.
Registered office is
Registered office of the defendant number 6 outside the jurisdiction of this court, but the head office.
The head office, my lord.
Registered office is outside. Corporate office at Rameshwar Road, Chittaranjan. But the corporate office is within the jurisdiction of this police. Counsel for the plaintiff further submitted some cause of action or part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, praise for leave under clause 12 of the latest patent. Consider the submission made by the counsel for the plaintiff, leave under clause 12 of the latter patent is granted. Plaintiff is admitted subject to scrutiny.
From the ledger, my lord, the entry is there, my lord. 13 September 2024 in my Karnataka bank account. Last payment was paid.
Next.
So I'm seeking my lord's leave to present a plaint. In my plaint, my lord, there is a suit for declaration, delivery up and cancellation of a sale deed dated 28th of June 2023, my lord. Why I am seeking for clause 12 leave is because the plaintiffs are outside. The defendant numbers 1 to 4 are within. The defendant number 5, my lord, is outside. I have also, my lord, pleaded sought leave under order 2 rule 2 because I have said that I have not been able to discover the full and further particulars of fraud that have been perpetrated by the defendants from within the jurisdiction upon the plaintiffs, my lord. I have pleaded the particulars of fraud at paragraph 23 at page 12 in the plaint, my lord. With respect to the cause of action, my lord.
The property is situated at where? Under the sale deed?
Property is outside the jurisdiction, but I have no prayer relief in respect to possession of the property. My relief is for declaration of
only
declaration and cancellation, my lord. Had I been
possession.
seeking, no, had I been seeking possession, my lord, I would not have been before my lord. My lord, I have pleaded my cause.
Where you mention?
My lord will kindly come to my prayers, my lord. At page 16, my lord. Prayer A is, my lord, that declaration that the sale deed dated 28th June 2023 is void, non-est and non-binding on the plaintiffs, and no right, title, and interest in respect of the suit property more fully described in Schedule A, hereto passed on the defendant number 5.
Correct.
Is the purchaser, my lord?
Yes. So
and
if you are telling that no right, title, and schedule title and interest of the property is passed to the defendant number 5, then it has to be declared the trust, title, and interest by the court.
My lord, kindly will also take, my lord.
Kindly come to the paragraph 29, sir.
Yes.
If the court has to declare that the defendant number 5 is not having a right or interest over the property, then it is
because, my lord, the deed of the sale
for
deed,
land.
May I, my lord, say this, my lord? If my lord will kindly come to the particulars of fraud that I have pleaded, the fraud perpetrates on the basis
This court is not on that.
Yes, ma'am.
If it is simplicity declaration, admittedly this court can entertain.
Yes,
but if you are coming in the pleading, you have pleaded with regard to the declaration, though you have not pleaded, but see, declaration of the deed is with regard to the property.
Yes, ma'am.
So you are telling that you have a right, the defendant number 5 is not having right.
Yes, ma'am.
Correct. So
yes,
the court has to declare, has to see with regard to the title of the property, then only the it is
subject to the test that my lord puts me through, my lord. If may I just show two things for the purpose of satisfying my lord? May I
66.
Yes. My lord, may I show the pleading and then the corresponding document?
That's why pleading for 29.
Yes, my lord, I am on 29, my lord. The pleadings of fraud that I have taken is that the defendants have, by dint of a legal
fraud,
action,
it's okay. I am not on the fraud. What about your paragraph 29, sir?
With respect to 29 itself, the deed has been registered on the basis of an instrument obtained from within the jurisdiction of
Correct. So
the
the court has to see,
yes,
by fraud, declaring that he is having the right title and interest over the property. That's why the deed is executed.
Yes,
now you have filed the case. He is not having the right title and interest, but the deed was executed.
Yes.
Then
may I then show my lord the alternative prayer that I have pleaded in the plaint. If
what
my lord kindly comes to paragraph page 17, my lord. if my lord kindly takes prayer E, my lord will find the basis.
Legal heirship certificate issued by the Kolkata.
E, my lord. E for England, my lord.
Alternative
sorry.
prayer B and C, A and B. A and B,
Yes,
again, the same thing.
This is, my lord, with respect to the consideration obtained by the defendants for the purposes of sale on the basis of fraud.
Unless the deed is not cancelled, how you can ask for the amount?
No, this is the alternative. If my lord declares that the deed of conveyance, deed of sale that has been executed by the defendant is not valid and is a product of fraud, and there is no, and my lord does not pass an order as against the defendant number 5, which is troubling my lord with respect to paragraph 29. My alternative prayer would be monies, my lord, that the defendant.
Again, the money kindly comes to paragraph 30.
Yes,
in the event sale deed dated 28 June cannot be cancelled, the plaintiff state that inasmuch as the plaintiff are 1/6 owners of the property. So ownership.
But my lord, fraud perpetrated from within the jurisdiction of this honorable court. No, I am not at this point not claiming possessory right over the property.
Come ready.
I am ready, my lord. If my lord kindly allows me to, there are judgments also on this point. If my lord allows me, I shall come back on the next day and place the relevant.
Come. That's I'm telling. Come ready.
I will
go through all pleadings, then come ready.
I am
not today.
May I, my lord, come tomorrow? Extremely obliged.
Next.
May it please, Your Lordship. But I'm presenting a plaint, my lord. The nature of the suit is for recovery of money, which has, my lord, now to be, which was lent and advanced, my lord. Originally, Your Lordship kindly takes up paragraph 3.
Yes.
The amount of 2,40,000, my lord, was a security deposit with respect to use and occupation of a property by the defendant, and after expiry of the 11 months, my lord, the security deposit was agreed between the parties to be converted as a loan, bearing interest of 16%, repayable on demand. That agreement was entered within jurisdiction. Now, my lord, in paragraph 6, I have stated that on January 13, 2025, I demanded.
How this court is having jurisdiction? 2,40,000?
No, my lord, 16% interest, it comes to 22
Interest can be calculated.
Yes. It is my rightful demand. It is my rightful demand as stated in paragraph 3.
At the time of final decree, the court will decide whether you are entitled to decree. But at the principal amount is to be taken into consideration for the pecuniary jurisdiction.
It has to be, because I have pleaded an oral contract in paragraph 3. And I have paid court fees, my lord, appropriately on the amount which I say is the subject matter in dispute. That is, my lord, paragraph 3. Read with, my lord, my particulars of claim in paragraph 7. The leave which I am seeking, my lord, is that the demand notice was received by the defendant who is residing outside the jurisdiction.
And 2011?
Yes.
Then what has happened after 2011?
But kindly see that the oral agreement was loan has to be repaid upon demand.
Correct.
And for the first time, as stated in paragraphs 5 and 6, if I may place, in January 2025, the defendant, by disputing the tenancy, has initiated eviction proceedings against the defendant. There is no mutual trust remaining between the parties. The plaintiff recalled the loan and for the first time demanded repayment with interest by a letter dated January 13, 2025, which was received by the defendant at her residence but not replied. However, hence the defendant has denied repayment. A copy of the letter, my lord, is also annexed together with the track information report.
In 2011, then you have demanded in 2025.
Yes,
this is also barred by limitation.
Kindly comes to, my lord, paragraph 3. Once,
yes, I have
where the contract is there.
Yes, I am going to order contract you have pleaded 16%.
The loan, including interest, was payable on demand. So, my lord, the first demand which was raised was on January 13, 2025, which remained, my lord, to be unreplied. And that is when, my lord, the cause of action arose for the first time. Because the arrangement between the parties was that they were never paying or demanding interest even during the interim period. It is the landlord who had taken this loan from the tenant. And when the landlord initiated eviction proceedings against the tenant who was the lender lost confidence and mutual trust and hence made the demand for the first time in January 2025. Since the letter, even after receipt, was not replied, we recalled the loan. And it was only happening, my lord, in January 2025, as we have pleaded in paragraph 6. This letter was received by the defendant who is staying outside the jurisdiction. And that is the reason why, my lord, a part of the cause of action has arisen outside. Even otherwise, the defendant is dwelling outside the jurisdiction. The point of, my lord,
2 point. One is the limitation. 2011, you issued the notice 2025. Second, with regard
my
to
lord, that letter we have specifically
and with
annexed. If
regard
your
to the
lordship wants to see.
2,40,000, whether this court is having jurisdiction, whether the interest is to be calculated at this is.
My lord, interest becomes a
If
part.
suppose tomorrow the court will say that you are not entitled to interest, whether this court can pass a decree of 2,40,000.
My lord, if the court is not, if the court declares that I am not entitled to interest, then the court, my lord, is also deciding that the oral agreement never existed. So my entire claim will fail, my lord, because I will have to prove paragraph 3, where interest is an intrinsic and undivisible part in my most humble submission, my lord. So my entirety of paragraph 3 at the stage of evidence may fail.
Your case is on
Paragraph 3
only.
Yes. And
three
paragraph
only.
3, my lord, takes into consideration the interest component. And at this stage, my lord, in my most humble submission, your lordship, my lord, will kindly consider that the statements made in the plaint, my lord, have to be considered as correct. My lord, the pecuniary value and the part of the cause of action has arisen within, as we have pleaded, my lord.
So suffering for the plaintiff. The plaintiff has filed the present application.
For clause 12 leave, my lord, the pleading is in paragraph 8.
Praying for the decree for a sum of rupees 22,53,294. Full stop. This court counsel for the plaintiff prays for leave under clause 12 of the latest patent on the ground that some part cause of action arose within jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Consider the submission made by the counsel for the plaintiff. Leave under clause 12 is granted. Plaintiff is admitted subject to scrutiny.
Deep acknowledgement.
Yes, next.
I will finish off. I will finish before my last fixed matter.
Yes.
Lordship's query was last occasion. Before I go to there, some points I want to show on their facts. The 8th November and 18th November. 8th November and 18th November.
Yes.
And also they had taken the point regarding secretary. I mean, they had taken the point, of course, without doing any substance, that secretary had no authority to ask him first place. I have got the minute books. Lordship knows this is under regulation 22. Minute book, and I've got the minute book. If your lordship wants, this is not available for their inspection, but I will hand up to my lord. First is, I've got the original minute book also. First minute is though. Give me the earlier one. Copy to. The relevant part term. Yes. 23rd October 2024 is the first one, where I can't give you a copy, sorry. Under the rules,
if they're relying on some document
Lordship's query, I'm answering. Lordship's query for your advantage, in fact. This is as per rules, this is only for committee. And also as per general law of the land. I had shown the Companies Act provision. Lordship kindly sees agendas, minute number 13, second page. I am reading out for their convenience. The CEO and Secretary Colonel M. Sanjeev brought to the notice of the committee a letter in the form of WhatsApp communication purportedly by Jai Surana, a member and a past president of this club. The CEO and Secretary, at the instruction of the committee for taking cognizance of the complaint, had sought verification from Jai Surana by an email of 9th October, which was perused by the committee. The Secretary placed the reply of Jai Surana dated 9th October, wherein Jai Surana took objection of the verification sought by the CEO and Secretary concerning the same. Decision: the committee opined that such averments needed to be examined in detail and Jai Surana be given an opportunity to explain his averments for proceeding further in the matter.
This is additional thing beyond Rule 22. We are giving them for this purpose, the members relationship committee to look into this matter and take necessary steps and hold a meeting in which Jai Surana be invited to explain the charges made in the WhatsApp communication mentioned above. The committee asked the secretary to implement the resolutions and refer it to the members relationship committee. This is how it went there. And Lordship, the second one, after the 8th MRC, there is the 18th,
8th November.
Sorry, 8th November MRC meeting, 8th November, where Lordship may recall, he had wanted he had
page 5.
So after you give me the question, you give it to me, give me some time. Oh yes, so no, he says, see, nobody asked me any question except whether it is my signature or not. Now I am not prepared to answer what I don't know what you will ask. So you give me a question. I will give a written reply so that everything is in paper, pen and paper. Apropos this 18 November was sent. Lordship asked, how did the secretary who was not there know about this and send this? You have truncated this. Why have you truncated this note? 18 November, there was a meeting of the committee. This is under the AGs.
Committee is 6 of these people.
Lordship, kindly come to paragraph 6, just above paragraph 6. I will read out for their benefit. Minute number 20, decision on WhatsApp communication purportedly circulated by Mr. Jai Surana, meeting held on 8th of November at 6 p.m. Mr. Jai Surana was called to meet the members relationship committee. Lordship, may I pause here for a moment? All the members relationship committee members are also members of the committee. On 8th November 2025 at 6 p.m. In the committee room, the Vice President, Mr. Kanan Tandon, the chairman of the Member Relationship Committee, played the entire video recording the said meeting. The CEO and Secretary, Colonel M. Sanjeev, veteran, was unwell on the said day when the meeting took place. Hence, the whole meeting discussion was recorded as a means of digital minutes of the meeting. Mr. Jai Surana too was briefed out and reasons behind the said meeting being recorded for the purpose of minutes only. Mr. Jai Surana initially asked some questions which the members relationship committee answered and assured to give him a copy of the proceedings. Mr. Jai Surana, having stated reasons for paucity of time, asked the members relationship committee to send him the related questions, if any, and the unedited copy of the video recording through a letter, which he will answer accordingly. Decision: the committee members agreed to the demand of Mr. Jai Surana and gave directions to the CEO and Secretary, Colonel M. Sanjeev, to send the unedited copy of the video recording along with the questionnaire, which will be provided to him by the members relationship committee after the ongoing meeting. So after the meeting, the questionnaire was provided. So at 6:20 p.m. on 18th November, the mail was sent by the secretary asking him, as per his request, that you send me in writing, I'll give my reply. His reply was, once again, you give me the minutes. And apropos this, I must show, after all, he is coming today at the ad interim stage, before affidavits. It's very important that there should be candor on his side. He should have disclosed, he should have shown, he should have made it part of his records that on 9th of November, after one day after the MRC meeting, this I'll give you a copy. Mail was sent by Mr. Jai Surana. All throughout, I wanted the minutes. I don't want video recording. Kindly see his mail. You are aware that yesterday, 8th November at 6 p.m., I attended a meeting convened by the MRC, wherein I was asked to appear. At the outset, Mr. Kanan Tandon, chairman of the members relationship committee, asked me whether a video recording of the entire meeting be done, to which proposal I readily agreed, subject to an unedited copy of the said video recording forwarded to me ASAP. All the members of the MRC, which included Mr. Kanan Tandon, so agreed that the same will be provided to me. Late yesterday evening, I had forwarded a WhatsApp message to Mr. Kanan Tandon, requesting him to forward the video recording positively by today, 9th November, to which request he replied that the same will be sent. Under the aforesaid circumstances, you are requested to kindly forward me the entire unedited video recording which was recorded yesterday during my meeting with members. So this is how this video recording was. It was very much, it was agreed since secretary was not there. Whole hue and cry. Even after 18 November, when we sent him the mail, he said, I will not reply till you give me the minutes. And this is what he had wanted. Lordship kindly notes, I had given my notes of argument. Lordship kindly come, this was supposed kindly come to my my written notes, page 9 of my written notes, which I had given them a copy.
Yeah,
We had disclosed all the mails which he had suppressed.
Yes.
Page 9, Lordship, kindly come to page 9.
Yes, 9th
9th November, email by the plaintiff to the Secretary CAC requesting for video recording of the meeting held on 8th November. But they know the plaintiff does not raise any demand for copy of the
Yes.
Lordship, page 37 is this annexure, but due to mistake, some other document was there. So Lordship kindly, page 37 was something else regarding the AGM.
So this will be the 37.
This will be piece of page 37.
Yes.
And Lordship, before I deal with their judgment, one principal point being urged by them that I will be expelled because you have asked me to expel. Lordship, kindly take a look at their look at the rules, because after all, he has chosen to be a member of this club. This is not the be all and end all in one's. This is not bread and butter like a salary job or things like that, but he chose it by choice. He chose membership by choice. Rule 22. Kindly come to last sub-rule I. At, she was the book, Sub-rule I.
Yes.
The special board shall arrive at their decisions by majority vote, either by show of hand or by secret ballot, as the chairman may determine, and the special board shall have the power to confirm, set aside, or vary the decision of the committee under subpara P, or to expel him from the club of the member whose conduct has been called in question. So he can be exonerated. And Lordship kindly sees D, subclause D. Most important is subclause D of Rule 22. The special board in such cases shall be constituted as follows. One is chairman,
Yeah,
three
that you're
and all the ex-presidents of the club as maybe in Kolkata. The average, I'm told, 29 to 29 ex-presidents are in the city. They cannot be that everybody is biased against him. So they'll all have voting rights. So 15 ex-presidents come, including his person, Nitin Dani, who he wanted to represent him at the MRC, which we allowed him at the executive committee meeting. He will also be there. All the ex-presidents, if he brings, and they can outvote the 3 committee members only, and the chairman. So it is like at the show, and only last thing is one judgment cited by them. Suresh G. Seth, 2019 SCC Online, Bombay 6683. This, kindly take a look at this judgment, Lordship. This was a case completely different. What happened was,
what is the citation?
It is 2019 SCC Online, Bombay 6683. Suresh G. Seth versus National Sports Club of India.
Judgments, right?
So we have an extra copy of that judgment.
Yes,
Got it. This was not a case where it was said that before suspension, show cause is required. But very briefly, this was a case where some of the members of this club called National Sports Club of India formed another club with a name somewhat similar, NSIC United. So the club filed a suit that you can't use this similar name, a trademark action. In which suit this plaintiff member and the others who were there came and first day surrendered, and there was a decree on admission passed that this name will change. Thereafter, this disciplinary proceeding and suspension was made against one of the members who formed this club, not all of them. And the case was that this plaintiff had the votes to stop 2 votes which would go against the incoming president, and the elections were just after the suspension, so that this person and one more person cannot vote. So the malafide was there. Lordship kindly sees page 3, paragraph 3, second page. Just at the bottom, learned counsel in this behalf inter alia refers to the following. In the first place, it is submitted that this action was in view of elections of the Central Council of the club scheduled to be held in Delhi and Mumbai, respectively on 10th and 17th. It is submitted that the misconduct alleged for suspending the plaintiffs is formation of an association called NSCI. This association has been in existence since October 17, and yet the controversy was raked up when the elections were around the corner. Several years later, in 19, when elections were around the corner, it is submitted that the show cause notice and the show cause was given, and the suspension, as the rules provide, which followed, were with a view to particularly target plaintiff numbers 1 and 2, who are current members of the elected General Counsel of the defendant, and plaintiff number 5, who had filed his nomination form for the upcoming elections of the Central Council, but had to withdraw his nomination in view of the original suspension order of so and so, which was later withdrawn as recorded order. It is submitted that the purported resolution of suspending the plaintiff's membership was with an ulterior motive of depriving the plaintiffs, and more particularly plaintiff numbers 1 and 2, from participating in elections to the executive committee of the defendant. It is submitted that the Central Council of the defendant is constituted of 60 elected members and presently includes plaintiff numbers 1 and 2. It is submitted that by suspending the membership of the plaintiff numbers 1 and 2, the group controlling the managing committee of defendant has effectively managed to oust 2 rival votes for the purpose of electing the president and other office bearers of the defendant. And Roman 4, it is submitted that the defendant club has selectively victimized only certain members of the United Active Force, a group of members active for long in the club, having 14 out of 6 seats in the Central Council in the last elections. The other active members, including one Kamlesh Jain, who is also a founder member of the United Active Force and who continues to be its member, even as of date, are spared because of their proximity with the current president.
Yes.
Now, on this basis, paragraph 5. It is true that ordinarily no action of a private club qua its members can be challenged in a court, save and except when such action is ultra vires the constitution of the club or in breach of principles of natural justice and fair play. And it is in this context, at the same time, it is important to note that expulsion member can have serious consequences. It is in this context. Now, kindly see the reason, paragraph 6. Kindly see the reason. If one has regard to the facts of the present case, the present action of the club against the plaintiffs is really in the nature of punishment. It seeks to restrain the plaintiffs from attending the club and participating in its activities for having committed a misconduct. The circumstances of the case noted above as part of submissions of the plaintiff clearly suggest that at least at this threshold, prima facie stage, there is a case to be considered at the hearing of the notice of motion on the malafides of the defendant's action in suspending the plaintiffs. In the first place, there is no definition of misconduct in the club's rule. Anything and everything which is against the powers that be is likely to be considered as misconduct. The misconduct complained of in the present case is formation of an association with the word NSCI as part of it and collection of money from members and so-called confusion caused by its functioning. It is seriously debatable if formation of an association by itself can be considered a misconduct. Even if, whilst forming, such such association, members of the club are roped in, or even for that matter, monies are collected from them, at least so long as the activities of the association, including collection of money, are not conducted in the club premises. That in any case is not part of the complaint of the club against the plaintiffs. Here it's circulation to all the members. The only grievance, if at all, can be the use of the name NSCI as part of the association's name. So even here, it is debatable if the grievance can be addressed when the disciplinary rules, within the disciplinary rules of the club. Be that as it may, a suit filed for redressing the wrong has already resulted into a decree on admission. On the very first day when the matter was brought before the court, the plaintiffs agreed to discontinue the use of the name NSCI and submit to a decree of perpetual injunction. There is no case that the plaintiffs are breaching that injunction or continuing to use the NSCI name. The grievance in that sense has been fully redressed. That directly poses some pertinent question. Why is the defendant still insisting on punishing the plaintiff? Does that really have to do with the elections that are around the corner? And where the presence, if not of the other plaintiffs, at least plaintiff numbers 1 and 2, is bound to make some difference? If indeed the grievance was about the association, why no action against the others, including Kamlesh Jain? And why act now if the association was formed in 2017? The defendant may well have answers. It may be that the defendants came to know of it now, but it may also be that they always knew it since inception and are latching on it now in bad faith. The defendant will have to state its case on oath. And then all this will be debated and a prima facie view will be taken at the hearing of the notice of motion. As of now, this is
yes.
So this is the nature of the wrong alleged on the part of the plaintiff, as well as the timing of the defendant's action, and the implications that such action may have vis-a-vis proposed elections are all matters which call for a fuller. So this is nothing to do here. That the plaintiff has performed a Robert Bruce. He has possibly stood 9 times in the elections and not been very successful, and this has got no connection with any elections. Nothing. Well, this is all, but only kindly.
Just 5 minutes, because
I gave a 5 minutes.
The question, why don't I'm a little
how can he?
Little concerned. Last time the order was counsel for the plaintiff has concluded argument. This court did not find what was the decision taken by the MRC in its meeting dated 8 November 2024, and whether the executive committee has taken any decision authorizing the secretary to issue the letter dated 18 November 2024 to the plaintiff. Now, the first one, whether the MRC has taken any decision or not. I'm not sure whether he's relying on some minutes now, because I'm told there's a minutes of 8th November.
Yes, there are no
18
minutes of 18.
Not 8th November, because 8th November, that was the question. So I don't know how he answers the question, because has said, how has the MRC taken a decision?
That court will strictly.
Yes, because in the letters, has seen his cases that the minutes are the videography.
I've sent that to you. You asked for it.
No. I'm sorry. That's not. I'm sorry. Just kindly make a note. Kindly, I know has already noted that from pages 260, 263, 262.
For the minutes.
265, where repeatedly, and we have also explained that you had said a videography will also be done. That doesn't mean minutes are not going to be given.
When on 9th of
quite naturally, minutes are.
And you suppress that letter by which you asked.
No, correct. What is? I'm sorry, just since he relied on this. Please, Mr. Mitra. Kindly look at this new document he gave.
It's not new document. This is something suppressed by him. Not new.
We have troubled the court for about 6 or 7 days. As you are aware, yesterday, 8 November, 6 p.m. I attended a meeting convened by the members' relation where I was asked to appear. At the outset, Mr. Sansach asked me whether a video recording of the entire meeting be done, to which I proposed a proposal I readily agreed, subject to an unedited copy of the said video recording be forwarded to me ASAP. All the members of the members, which included Mr. Kanandan and Sansach, agreed that the same will be provided to me. Late yesterday evening, I forwarded a message requesting to forward the video recording, which same will be sent. Where do I say that minutes won't be there? You want to additionally, you say the secretary is not there, I want to videograph it. I gave my consent because without my consent, you could not. So I've said, please send me an unedited copy. I have not said here that now you dispense with the requirement of the minutes, which are required in the articles itself.
As per articles,
Mr. Mitra, we can't go on.
He's not entitled to a
Mr.
copy.
Mitra.
Member is not entitled
No,
to
it requires.
Let me allowed to decide.
Yes. Just one. My learned friend says I'm not entitled to copy of the minutes. Then why did he send me the videograph? Because he says that's the minutes. It's a self-defeating argument. Self-defeating argument. He said, I'll send you the videograph, I won't send you the minutes.
Okay.
We have our notes.
Filed.
We have it. Give it to him.
Deferred number 2 and 3 as filed. Plaintiff note is not here. You will file the notes.
We have prepared it. I'm told some corrections have to be done. We'll give it by tomorrow. In the morning, we'll give it.
Tomorrow.
To my lord's office.
May have a copy after. I have given my
yes, of
copy
course.
to him.
So suffering for the plaintiff, suffering for the defendant. In hearing concluded, full stop. Counsel for the plaintiff submitted. He will file the written notes of argument by tomorrow. Let the matter to fix tomorrow as to be mentioned for filing written notes of argument by the plaintiff.
Okay.
Has to be mentioned. Has to be mentioned.
We are putting everything, and including the 29th January, which is a very crucial letter for us. I'm so grateful, Mullah.
Yes, next. Item number 14. Itna bill dik the 14
But I am appearing for the plaintiff in this matter. There is a change.
My lord, I beg to appear, my lord, on behalf of the one of the defendants.
Only difficulty before I proceed with the matter is, my lord, my advocate on record has got a change, but the erstwhile advocate on record are not endorsing their no objection. The client has given a fresh wakalatnama accordingly in favor of my advocate on record. We will be praying for your lordship's leave.
Your lordship kindly cross me.
Allow my advocate on record to file it in the department.
For plaintiff?
For the plaintiff. And this is the letter from the constituted attorney of the plaintiff to the erstwhile advocate.
My lord, will it be my lord's pleasure, my lord, to take it up on Monday?
If my wakalatnama is allowed to be filed, well, it can be taken up for Monday. I have no objection to that.
I don't have a say on your wakalatam. I have got no objections on that.
Yes.
Your lordship, I am appearing for the
problem to solve.
Our joint decision, the plaintiff was authorized to pursue all litigations pursuant to this treaty, with respect to challenging the Shivachi and others. Now, I also do not have any knowledge about this change or whatever this power of attorney.
One of the defendants.
How can he have any? How can he have?
It was a joint decision. Now, this change I am not aware. But instructions on that. Next, I will be in a position to assist you.
The only prayer, my lord, only prayer I was. The only prayer I was making is, if your lordship considers keeping it on Monday, instead of Monday, keep it on Tuesday.
Your lordship keeps it any day after 17th. Mr. Jaitley is appearing in the matter. Your lordship kindly keeps it any day after the 17th.
Why?
Mr. Jaitley is appearing in the upper. He's appearing for the deity. Today, if the
No, who's representing the deity? That's a problem. That is
My lord, I think my lord, as a preliminary part, my lord, we need to know who is for whom and when.
Let first decide who is appearing for
who is for whom and when.
Yes.
Your lordship goes into this. Lord, I have come to know from the cause title and also, my lord, from my cousins who are included in this litigation, my lord, that I am not a party, whereas, my lord, a declaration is sought that certain properties belong to the deity.
No, that declaration is not sought.
No declaration of that
I have
sort.
not, my lord, been given a
No,
copy.
no.
Lordship kindly sees this, my lord.
You apply.
It is not. It is for
You apply.
Now, allow me to make the submission. Milord, kindly have a look at the genealogical table, Milord. I'm sharing it with Mr.
Let me see.
No, we are as it is confused about who is for whom. Let not an outsider come and say, I want to become another man.
This is something very important.
Brother, let us arrange our affairs first as to who is for whom in the present cause title.
Where is the plaint?
Where is the plaint? Who is for whom?
You are not annexed the plaint in the.
Yes, your lordship,
They have
plaint
not
is
done that.
annexed
Where
in
is
the
that?
injunction. It's a
Not without annexes.
Where is the plaint?
71.
It's
Your lordship.
271.
271.
271. That's plaint without annexes.
Correct. So plaintiff Sri Ishwar Sitaramji and Swapna Mukherjee is appearing.
Your lordship, I am appearing for them.
I've got a fresh wakalat.
Your lordship kindly hears me. Sure, I know the plaintiff number 2 personally. I've been trying to reach her since yesterday. Her phone is switched off. Yesterday, I'm receiving a strange mail from the daughter that please don't act on her behalf.
Okay. So you are appearing for the plaintiff earlier. You are the advocate
Yes, your
on record.
lordship. Yes, your lordship.
Correct.
Yes.
Now you have received any information because.
No, your lordship, I can't reach my client only. Her phone is switched off.
So that's why one.
Where is the client in the? She is not my client. Her mother is my client.
What is your name?
She has signed the complaint.
What is your name?
Monisha Mukherjee, sir.
Huh?
Monisha Mukherjee.
Who is you?
She is the signatory of the plaint.
How you are connected with this case?
My mother is.
Your lordship, she is not connected. I am just trying to clarify.
I'm her daughter and I want to change my lawyers.
You are daughter of Swapna Mukherjee?
Yes.
Why is her phone switched off?
What is the age of the Swapna Mukherjee?
She's in her 80s.
And you are the daughter.
Your lordship will remember how contested
The daughter has the daughter has affirmed the plaint and verified the pleading.
Now your
Daughter has verified the plaint.
the original plaintiff. How can you just say that?
How can I have such an interested advocate on record?
Okay.
Who will penetrate the air and go to
one? Who is for the defend number 1?
Brother, just a second. Let us get our
Respondent number 1, Milord, Mr. Chatterjee, virtual.
I appear, my lord, on behalf of the defendant number 1.
Okay. And defend number 2?
Milord, I am appealing for defendant number 2.
And defend number 3?
Lord, I am for 3. I am for defend number 3.
And 4? 4, nobody is appearing. 5?
4, 5, they have not been served. I think this was ex parte. So I was on caveats. So, my lord, we were served.
6? 6 you are appearing. 7?
I am appearing, my lord.
7 you are appearing. So except 4 and 5, all the persons are appearing.
Yes.
So with regard to what Mr. Kamaka, what is the submission that it is a joint?
The entire persuasion of Milord this suit with respect to challenging the Shebayatship or Milord setting them aside. Now, Milord, that was a joint decision taken by Milord the managing committee of the Deferred.
Correct.
We are also part of that.
So you are supporting the plaintiff's cause.
Yes.
So who are against the defendant?
Who is Mr. Karmakar appearing for?
Karmakar is for the defendant number 6. Who is against plaintiff's cause?
I am against the plaintiff's cause. I am saying that
I am against the plaintiff's cause.
Correct. Whether any resolution has been taken?
no, there is a complete.
nothing.
There's an attempt to take over the functioning.
Your lordship, we have got an order.
My lord, I'll tell you, lordship. There's an attempt to take over. Please bear with me for half a minute. It will come clear.
I will give 2 minutes.
Let this dispute be first.
That's why I want to understand what is the actual cause.
The trouble is, the plaintiffs who are presently, the plaintiff who is presently appearing to champion the deity, according to us, does not have any right, title, or interest to champion the deity.
Not even a Shebayat.
Record to show that she is not a Shebayat. I have got materials on record to show that she is bound by past declarations made. Now, these are questions of. Now, as far as therefore, my lord, while I say I oppose, I am not saying that I am opposing the cause of the deity, but I am opposing this plaintiff standing up as the representative of the deity.
So you have no concern with whether who is appearing for the plaintiff?
No, we don't have any concern.
Whoever is appearing, my lord, whoever is appearing, subject to the proper person appearing.
No, that's why. No,
Yes.
with regard to whoever
appears,
you are
he
no
has
concern.
to will not tow the plaint case, and
that's
to
why.
that I will have to make my objection.
I am opposing this injunction application.
Injunction, I will not.
Actually,
Yes,
no.
now the first cause is that with regard to the change of lawyer of the plaintiff.
Yes,
Representation of the plaintiff. Correct.
We cannot be
So
bothered
you are
who's
not-
appearing. Yes.
Only Mr. Kamak.
Have a look at the verification of the plane.
And I have gone through.
Now, the person who has verified is here.
Lord, when I will take out an application for getting myself transposed, Lord, as a
Whatever he does, not let him
That
not
is up
share
to
his
him.
advice with us.
Do that you can.
Let him not share.
Verified plane is before
So you are the earlier advocate on record.
Your lordship,
Mr.
I'm the
Mr.
advocate.
Kormukar was once appearing for the
You
Manisha
do one
Mukherjee
thing.
somewhere
You do
else.
one thing. Yes, she's present
Yeah.
here. Whether Sapna Mukherjee come before this court. Whether you why?
He's bedridden, sir.
She is bedridden.
Your lordship,
Okay,
you've met her.
I will appoint a special officer whether she is continuing to with the earlier advocate or whether
Absolutely, absolutely.
special officer go and come with the report. Whether he is telling that yes, she has
Yes.
withdrawn the power of the earlier advocate, wanted to engage another advocate, this will be
I think, my lord, your lordship can do that, but I think, my lord,
And whether she at all wants to proceed with this matter. Whether she at all wants to proceed with the matter.
It is Mr. Rahul
My
Kormukar.
lord, we
Lord.
have serious doubts here.
it's not their concern, my lord.
whether plaintiff wants to proceed with the
Mr. Rahul Kormukar Lord has some axe to grind with Mr. Chatterjee, which is grinding at the bar here.
Yes, I wanted to tell that you.
Yes, so that came to my mind. Some axe to grind, Lord, which he couldn't have said in chamber 4 years ago. He's grinding that axe here.
My lord, may I just say this, my lord, kindly take David verifying the plane. Because your lordship is saying that that person has to be examined, but here, kindly see, he has affirmed this as a constituted attorney of the plaintiff number 2.
Correct.
So she has a valid power of attorney.
Correct.
Today at this stage, if Swapna Mukherjee cannot say anything unless Swapna Mukherjee revokes this power. So I think
Where is the power is there?
Well,
the power of attorney?
Page 27.
the issue
Affidavit very
Mr. Kormukar, please.
just one second.
Where is the power of attorney? Power of attorney?
Competence.
Printing नहीं है ना?
Because no one has disputed this power. My learned friend who is representing, she has come to your lordship on the basis of that power.
Your lordship, the power
So,
was
but the
limited to the
power
fact that she is very old just
but
for
the-
the signing.
Who has signed the wakalatnama on in your?
Manisha.
Daughter has signed, but
Yes,
I,
doctor.
Just a minute. Who has signed the wakalatnama?
Manisha Mukherjee, your lordship, I agree,
No,
but
she is
I,
present here.
but your lordship, I
She is a
was,
constituted attorney. Either you to come with an document that power of attorney has been revoked. She has
your
no power.
lordship, just hears me out for a minute. I was dealing with Swapna Mukherjee. She said that she's old right now. She doesn't want to come to court and sign. She's really having problems moving around. So that is why she said my daughter will go and sign.
Correct.
Today, if the daughter is getting influenced by this matter, I don't know what is happening. I can't even reach
What is
her.
the matter of influence? It is a matter of
Your lordship,
Lord, I am
consent to
requesting
proceed with the
my
matter.
learned sister. I am
lordship is
requesting
very
her to the
highly
bar. Let her not.
Sure.
There is she's a very young member of the bar. She's my learned sister. We are all part of the same fraternity. If a client does not want to
Correct.
remain with you, don't cling on to the client.
That's
Please, sister, it will have a.
But
You will
Mr.
have
But Mr. Banerjee, let my lord find out for whom he
That's
wants
difficult
to
to
appear.
find. Don't
Your
cling on.
lordship,
It paints a very poor picture before
Swapna
court.
Mukherjee is
Sister,
not
you are
my-
young. Sister, you are young. I have spent 25 years in the profession. I have gone through many such situations where one client is represented by 5 advocates who are fighting with each other. Don't get into this melee at this age.
I had contested a case amongst the lawyers with regard to the signing of the wakalat.
Signing of the wakalat. Just, oh, I'm saying, please, let us fight over issues. Let us fight over issues of the clients. Let us not make an issue of who wants to fight.
Your lordship,
Now,
I
Mr. Banerjee,
attorney is present. She is telling.
She's saying here, sister, this
your
is.
wakalatnama has been
your lordship
executed
gives
by
me
the
some
attorney.
time to come back.
For what?
Oh, for what? You are no longer on board.
For
Sister, this.
And your lordship,
Sister, please. Sister,
Swapna
please.
Mukherjee is not my only client.
Sister,
I am
please.
also
Sister, please.
representing DT, your lordship.
Sister, please.
How can DT I have one humble submission.
Ah.
Lordship kindly takes up genealogical case.
Hmm.
I may not.
If you see, if you have, the court cannot advise. If you want, you
Apply for addition.
The difficulty, my lord, I am aware of. But I am one of the necessary parties.
Who? Which place?
Lordship has the genealogical.
Yes, which place?
Lord, I am, my lord,
Last one.
Banerjee.
Last one.
Yes. No, because this is the generation who are at present before. And the Rebotto estate is supposed to be, the settler is supposed to be Uttal Chandra Banerjee or Bandyopadhyay. So, I am a party, who is the heir of.
You comes from the.
I come from one of the daughters of Uttal Chandra Banerjee.
No, not daughters.
Comes
Sons, daughters,
daughters,
sons, daughter's son.
Yes. 1918, the original settler had passed away.
Reminds us of our Hindu law classes. Sons, daughters, daughters, son, sons, daughters, son.
But this matter is on Hindu law, so you would really have to remember that.
Stage when certain rectifications are called for, I must, in my most humble submission, notify to the plaintiff that I deserve to be added as a necessary party.
Apply.
Well, we have just.
He's been notified.
If you want, you had the knowledge with regard to this.
Order 1 Rule 10, apply.
Come with an application, they will get an opportunity to. What
Liberty.
for addition of party? There is no addition and deletion. There is no requirement of the party.
Not be my advocate on record will not be able to file a wakalatnama unless there is an expressed leave granted only to file the wakalat.
I will grant this. Come
For the purpose of Order 1 Rule 10, yes.
Come with an application.
Come with
I
an
will
application,
grant
take
you.
the leave.
This court will grant you leave.
We always do that.
Yeah, my lord, at least beseech the plaintiff to favor me with a copy of the injunction application so that I can get hold of the cause title. Unless
I will give you the cause title.
Acha Baba, we'll give you. These submissions shouldn't be made in court. These have to be made in the library. Please. We'll give you.
Okay.
Acha.
Protected.
We'll give
You have been given liberty. You go. You file an application.
for
If
addition.
you have any difficulty, come this court.
Yes.
ask the plaintiff to give me a copy of the file.
Your lordship,
How
kindly
can
give me some time.
Sister, please. Sister, you will be in trouble. Please. You're a very young member of the bar.
You're not
Please.
letting me talk.
Sister, please.
Senior
Please,
advocate,
sister.
Mr. Sakesh and Leonard, senior advocate, appeared on behalf of the plaintiff and submit that he has got, the advocate on record has got, not advocate on record, the learned advocate Sanoni Bose has got an email from Manisha Mukherjee requesting on behalf of her mother, Swapna Mukherjee, with the request to appear, with the request that they have advised the elder advocate on record not to appear in the matter and requested the present advocate to appear on behalf of the plaintiff in the matter. Learned advocate appearing on behalf of the plaintiff earlier, the earlier advocate on record of the plaintiff submits that prays for time to take instruction from the plaintiff whether she is really interested to change the advocate on record of the plaintiff. Full stop. When the matter is called, what is the good name?
Manisha
Mukherjee appeared in person, who is the constituted attorney of Swapna Mukherjee.
Daughter and constituted.
Daughter and constituted attorney of Swapna Mukherjee, and submits before this court on query that her mother, Swapna Mukherjee, is not intending to continue with the elder advocate on record and they intend to change the advocate on record. Accordingly, she has made a request to the present advocate to appear in the matter on behalf of the plaintiff. Learned Senior Counsel Mr. Sakesh Sen prays for leave to file wakalatnama on behalf of the plaintiff. Accordingly, leave is granted to the learned advocate on record of the plaintiff to file wakalatnama in the department within a week from date, subject to verification. Full stop. Earlier advocate on record intend to take instruction as the Swapna Mukherjee is bedridden.
Your lordship, for the interest of DT, kindly gives me some time.
No.
She is present. If she is not present, I could have been granted.
But your lordship, she is nobody. She is not a
You
Sheba.
have taken the wakalatnama from her. You have filed the
Yes,
plaint.
only
Sister, you don't do this, sister. Please don't do this.
She is not understanding.
Please don't
Yes.
do this.
But may I beseech your lordship kindly record my humble submission.
So Mr. Rohit Banerjee, an advocate, has handed over a genealogical table of the family and stated that he is also got interest in the matter and he may be granted leave to file
On
appropriate.
behalf of Saugata Banerjee.
क्या बोला? Yeah. And submit that one Sugato Banerjee, who is also having interest in the property, and he may be granted leave to file proper application to add as a party. This court find that there is no leave is required to file the application for addition of the party, comma, Mr. Banerjee is having if the Mr. Banerjee is currently intent to add in the suit, he can take appropriate steps.
I request that a copy of the application is served.
How can that be? How can the honorable court say that when you are a non-party? We will give you.
Now,
No, my lord, your lordship will kindly see, my lord, this is an injunction application, but my principle.
The Wakalatnama is yet to be filed.
you file Wakalatnam, I am fixing after.
Yes, yes. My lord, in the meantime, let us file our affidavits within a short period. Let us come.
Affidavits are not filed.
No, not filed. Let us file our affidavits. Let us file our affidavits.
Let them place.
One, so and so appearing for the defendant number 2, so and so appearing for the defendant number 3, so and so appearing for the defendant number 6, and so and so appearing for the defendant number 7. Counsel for the none appears on behalf of the defendant number 4 and 5. What about the defendant number 4 and
5 have not been served.
What is served?
I think we have to serve them.
Oh, 4 and 5 have to be
Plaintiff
served.
is directed to serve the notice upon the defendant number 4 and 5 and to file affidavit of service on the returnable date. Counsel for the defendants press for time to file affidavit in opposition.
Yes, my lord. My lord.
Let affidavit in opposition be filed within 2 weeks. Reply if any there to be filed within a week thereafter. List the matter. On 16th April.
Not only one prayer. If your lordship gives a similar direction to those who have been served.
My lord, kindly do not keep it on the 16th April, my lord. 16th April is a very problematic period. The week thereafter.
Oh, my lord, no. My lord, 16th April is a deemed.
2 days are there.
The record 2 days. Both have been subsumed.
Both
have been subsumed.
Tickets have already been booked.
Both have been subsumed. It is again a seaside, but not in India. This time it is Bali.
That goes without saying for Mr. Banerjee and Mr. Chatterjee.
The Goans will be very annoyed if Mr. Banerjee doesn't go to Goa.
Again a
They
seaside.
will go to such places
Mr.
where
Chatterjee
they
goes-
can't even join by video.
Mr. Chatterjee
possible.
goes to extreme places of Norway. My lord will find cliffs, fjords, and Mr. Chatterjee. Nothing else.
Or in the Congo with
Mr. Banerjee, my lord, is in the habit of demeaning me.
gorillas, 20 orangutans, and Mr. Chatterjee.
Bojo, kindly see, my lord, what I am compared with. Kindly
Mr. Chatterjee, you got the cause of action to file the suit.
Exactly, I shall do that. He will have to compensate me, my lord.
In the jurisdiction.
No, but according to Darwin, my lord, I am right. According to Darwin, I am right. So, my lord, if it is not untrue, it can't be defamation.
Last week of April, because there's some urgency in the matter, my lord.
Mr. Kormokar is appearing for a defendant. He can't have urgency.
10th April.
Unbelievable.
10th April.
10th of April. 10th of April.
Mr. Chatterjee, 10th April.
Very well, my lord. No problem. But I'm surprised Mr. Kormokar, my lord, has urgency. He's appearing for the defendant.
Outside, we will see, my lord.
I'm
My lord,
cautioning
sometimes.
Mr. Kormokar.
Quite unbelievable.
Of interest. My lord, he appeared for Mr. Swapna Mukherjee in other court.
Yes.
Stop, no, there is no conflict of that interest. There's a different conflict of interest. Mr. Aniruddha Chatterjee must have given him a dressing down for not finding the proper judgments. Now he is fighting.
Now I am not a human being who dresses anybody down, my lord. Far away, my lord, Mr. Kormokar.
Dressing down in that sense.
Okay. Thank you.
Grateful, my lord.
Yes, call the matter.
Let please ask him where he is going this time. Congo.
Nowhere, my lord. Nowhere.
Where?
Nowhere, my lord. I'm in Jalpaiguri.
That
my
I
lord.
am going
can't
tomorrow.
open my
That's why
window.
seaside is.
Seaside. But not only in Goa, sometimes in Port Blair also.
Seventeen with 18. Okay, it's Jalan.
Lordship, I'm for the petitioner. I'm led by Mr. Shakosen. He
Left
the respondent.
Go and catch hold of. Just is leaving the courtroom.
has another matter which is already going on, Your Lordship.
So what do you want?
Could you grant me a short password? Because your lordship, today in the list, your lordship's list, fixed matters are there at 2 p.m. and 3 p.m. as well.
What is the matter? You are appearing for?
I'm appealing for the respondent. An application has been filed by Mr. Ghosh was appearing in this matter. Your lordship would, if your lordship remember, that an application has been filed, demurrer application, that the application for originating summons suit is not maintainable, your lordship. Your lordship also advised
of land.
lordship. Okay. So let it appear in the month of April in that case, your lordship. Because on the last 3 occasions, the matter was.
Let the matter appear in tomorrow's list.
Not today.
Yes. Grateful, your lordship.
And this is my application, my lord.
I'm for the defendant number 2, my lord.
It's a substitution application, my lord. The defendant has died.
Defendant died.
Yes,
How many defendants are there?
Well, there are three
Three
defendants. but
defendants
two
are
and three
there.
are
3 is
pro
the
forma.
performer.
Yes,
1 and 2 are the main.
defendant is defendant number 1. He
Who
has
died?
filed- Defendant number 1 is died, man.
Yes. When he
has
died?
He died on 24th of November, 25th of November, my lord. Page 6, my lord.
Page 6.
Yes, my lord. 25th November 2020.
Page 6 of GA 5.
25th November 2020.
Which GA? GA 5?
Yes, my lord. GA5.
Where is the death certificate?
My lord, we could not procure the death certificate, my lord. We have requested the learned advocate who was appearing for the.
You are disputing the death. Mr. Datto? Disputing death?
Can't.
No, disputing the death, then other. Yes. Yes, then what is your objection? Any objection?
No objection.
Yes.
Only one problem that they have served us. We were appearing for the original defendant. Now, once they substitute and bring in record on the names of the heirs, leave be granted to us to file the wakalatnama. Leave be granted to us to file the wakalat.
Yes. Where is the date of death?
Page 6.
Page 6,
4.
paragraph
4, my lord. At the first line, my lord.
During the pendency of suit, defendant number 1 died on 25th November 2024.
Yes.
Then, where is the legal layer? Where is the details?
My lord, it is at page 7, my lord. The chart, my lord.
Priyanka Bhattacharya, Mohana Bhattacharya. Both are daughters.
Both are daughters, my lord. Both are
What about the wife? Wife is not there.
No, my lord. Wife, predeceased, my lord.
Predeceased.
Yes, my lord.
Okay.
Para 7 at page 6.
Only the name of they have written this name of the second daughter as Mohana Bhattacharya. It should be Mohana Moitro. Oh, I have
Yes, who is appearing for the defendant number 2? You are appearing. Any objection? No objection. And performer defendant? Nobody is appearing. Calcutta Electric Supply Corporation Limited.
What is the suit for? Declaration.
Let's suit for declaration.
Mohana Moitro, my lord. She writes
Yes, what is
Mohana
the name?
Moitro.
Mitro.
Moitro. M-O-I-T-R-A.
M-O-I-T-R-A.
She is using that maiden title.
So you have to correct the names.
My leave may be granted, my lord.
The address is correct.
Yes, my lord. This is a suit property. This is the address is correct.
They are residing there.
No, my lord. They
No,
are the married daughters.
They are the married daughters.
How it will be served?
My lord, I do not know whether
You are
they have-
appearing?
No, they have served us, but I need to file my wakalatnama
Correct.
first.
So you will file wakalatnama, na?
File my
Otherwise, then the address, if they are the married, then address should be difficult. Then the suit will remain pending.
No, my lord,
If
if
the
they
amendment-
knows the address, my lord, we do not have the address, my lord. If they knows, let them supply the. My lord, that's why I issued a letter to the advocate on record, whether they have the
So
information.
whether you will receive the notice of the amended prints. And you
let
can-
that let that service be affected
So
upon the
that
client.
is with the service affected, you have a address of this.
Then let me get the address. Let me get the address and
Take the address.
Yes, my lord, I've given the letter
I will-
on 17th December. But they
at
could,
that point of time, we were unable to contact the daughters because my advocate on record had the contact number of the original defendant. The once he died, his phone also got switched off. We could not get. Thereafter, we got the names of the daughters. At that point of they asked us to give us, but we were not having a contact with the client. How can we give them the names or
So what can be done? Can I allow this, or you will wait, or you give the address?
I will give them an address.
You will give the address?
Give us some
my
some
lord, that
time.
will be better, my lord. Then I can make the
You are
changes in
having the
plea.
address?
No, my lord.
You are not having the address. So and so appearing for the plaintiff. So and so appearing for the original defendant number 1. And so and so appearing for the defendant number 2. The plaintiff has filed the present application for recording the death of the defendant number 1 and substituted the legal heirs of the defendant number 1. So counsel for the defendant, the original defendant submit that the name of one of the daughter has been wrongly mentioned in the present application as Mohana Bhattacharya instead of Mohana Moitra, M-O-I-T-R-A. Full stop. The counsel for the plaintiff further submit that the plaintiff has mentioned the address of the suit property, but the daughters are not residing in the said property. Accordingly, he has requested the learned counsel for the original defendant number 1 for providing the address, but he has not provided the same. Counsel for the original defendant submit that he will contact the daughters of the original defendant and provide the details of the address of the legal heirs of the original defendant number 1 to the learned counsel for the plaintiff. In view of the above, so counsel for the plaintiff prays for time for taking appropriate steps to correct the name of the one of the daughter of the original defendant, as well as providing the correct address of the legal heirs of the original defendant. In view of the above, the case is adjourned. Let the matter appear on 9th April.
Yes. 9th.
Yes.
I appear for the defendant number 1.
Number 3 and 4. As regard photographs.
Not I am for the plaintiff.
Yes.
By the last order, my lords had appointed a surveyor. The surveyor has circulated his drawings, to which all the parties had given their viewpoints. So the surveyor will be taking into consideration those viewpoints and will be circulating the drawings once again.
So I am adjourning the matter.
That's right. I mean, what my learned friend said is actually correct. The drawings that were circulated, they were inaccurate to a large extent, and we pointed them out too. And they've had the meeting on this Sunday in the evening. And we've pointed out that these are the inconsistencies and inaccuracies. And we've called upon him to kindly correct the drawings. And thereafter, we will sit down and see what is important, my lord. There are 3 steps required to be done. And the very first step is where we are getting stuck at, which is the measurement. The drawings have to be done. Thereafter, the allocations have to be decided, and thereafter, the eventual report will finally come. And we are stuck at the first stage. I have no difficulty with that subject. The commissioner himself says that, yes, we will rectify whatever your views are, and we will come back and sit again. In my opinion, my lord, I don't think this can be done in a great deal of hurry. Subject to what the others may say, your lordship will keep it over for maybe 2 months, because this is not something that's going to be done in a hurry. And we don't want to come back again and again to your lordship to trouble your lordship on this.
The only difficulty is if my lord keeps it 2 months, then it will go beyond 2 months for sure. If my lord keeps it in.
Okay, I am fixing before vacation.
Okay,
yes, before. Certainly before the.
We are on May.
That's
April,
right.
I am fixing the.
Early May, your lordship can fix it.
I am fixing on 7th May. Let in the meantime.
Your lordship, can you give me a moment, please?
My lord, there was
6th or 7th May. 6th, no, 6th is the commercial day. 7th or 8th.
7th or 8th is fine.
My lord, there was one more prayer. My lord, during the commissioning, there have been objections and inappropriate words being used by one of the defendants. My lord, my humble prayer will be, if my lord thinks so appropriate, can give directions for video recording. We will
automatically, your the special officer is having the right to do all the photographs, video recording, whatever it is.
No, my lord, if my learned friend's submissions are to be taken to be correct, because I was not physically present, and if they are from my clients,
My lord,
I will ensure that nothing of the kind happens.
I don't want to submit this, but like the advocate representing the plaintiff, he has been called illiterate and other inappropriate words have been used.
By who?
By Mr. Dilip Khandelwal.
If that be the case, my lord, I will ensure that my clients don't indulge in this. That I can ensure.
For the plaintiff, so appearing for the defendant number 1, so appearing for the defendant number 2. Full stop. Commissioner is present now. To counsel for the respective parties means that the survey commissioner has surveyed the property and has given the proposed survey reports to all the parties, and the matter is, and a meeting is fixed for taking consent of all the parties with regard to the proposed survey report. It is further submitted that to complete the survey and partition of the property will take further time. Accordingly, both the parties press for fixing the matter after some time. In view of the submission made by the counsel for the parties, the case is adjourned. Let the matter appear on 7th of May 2025.
My lord, just two things. My lord, in the first part, my lord, if I'm not mistaken, it has been said that the report has already been prepared.
Proposed report has been served. Proposed report, the survey, proposed survey report has been forwarded to all the parties.
I think what my learned friend is saying is it's not a report, it's the proposed drawings.
Proposed drawing, the report, proposed drawing.
That's right.
Proposed drawing has been circulated by the surveyor to all the parties, and the meeting is fixed. Accordingly, the counsel for the plaintiff prays for time. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 8th of May.
Will my lord just put a one-liner that the commissioner, if so feel, can video record the proceedings, because
full stop. Counsel for the plaintiff submits before this court that during the commission, some of the parties have raised some vulgar language against the advocate on record of the plaintiff. Accordingly, the partition commissioner.
Yes, my lord.
Or surveyor, partition commissioner.
Commissioner, and he has been given liberty
The
to appoint.
Commissioner is at liberty to do all the partition work and all the meeting within the by a videography.
Your lordship will kindly record, my lord, that I am not admitting that this has happened.
No,
but be that as it may, I'm taking the
by a
responsibility.
videography, and all the parties are directed not to use any vulgar language.
This is not something that ought to have come out in the court, really.
And I ideally shouldn't have, but this has been happening in many.
At the time of holding commission by the partition commissioner.
These are things to be amicably settled outside the court. It shouldn't have come out here, really.
Grateful, my lord.
The specific performance suit.
Yes.
They were making submissions on the commercial court or not.
Your Lordship, I appeared on behalf of the respondent number 3 and 4. I was being led by Mr. Ghosh in the. I'm being led by Mr. Ghosh in the matter. I'm just seeking for an adjournment.
Not today.
Lordship, then on their prayer, because in the appeal court they will sit there. Kindly record that.
So suffering for the plaintiff, so suffering for the defendant. As per the prayer made by the counsel for the defendant, the case defendant number 2 and 3. The case is adjourned. Let the matter appear tomorrow.
Your Lordship, if I may just pray for next week. Tomorrow there is a resolution from 115.
Case is adjourned. Let the matter appear on. Let the matter appear on 26th March.
Much obliged, Your Lordship.
This is my application. I was directed, my lord, to deposit my show cause, my lord. I have, my lord, prepared it.
This is my application for attachment before judgment, my lord. The suit is for recovery of an amount of in excess of rupees 25 crore. On the last occasion, my lord had directed them to show cause, my lord. They have filed a very short affidavit, my lord, and I believe, my lord, this does not show any ground why they should not be directed to furnish security. In fact, if my lord kindly takes their affidavit once, kindly takes, my lord, page number 3 of that affidavit, my lord, he stated, I say that in any event, even if the properties of the defendant are disposed of, the same shall be put into use to clear off the dues of the plaintiff. So, my lord, they are not denied, my lord, that they don't intend to sell off the properties. My lord, will kindly see paragraph 7, 8, and 9 as well. By letter dated 10th January 2024, defendant herein had sought to explain the plaintiff its situation and also requested the plaintiff to allow 4 to 5 months' time to repay the dues. My lord, we had given that time, my lord. Paragraph 8, I say that the said letter dated 10th January had been wrongly represented by the plaintiff to be an admission by the defendant. The said letter was issued in good faith, and the defendant in the said letter dated 10th January 2024 has stated they intend to liquidate the dues of the plaintiff, but owing to acute financial crunch, the defendant number 1 is not in a position to pay off the same. Paragraph 9, I say that the defendant never had any intention to deceive the plaintiff, and it was only due to acute financial crunch faced by the defendant, which is continuing till date. Defendant is unable to pay off the dues of the plaintiff at present. The defendant has all bona fide intentions to pay off the dues of the plaintiff. Paragraph 10, the plaintiff, knowing fully well the defendant is in a bad financial state, proceeded to provide the facility to the defendant. The plaintiff was well aware of the fact that the defendant shall not be able to repay the dues within time stipulated and took a conscious risk. My lord, this is not a show cause which would satisfy as to why they should not be directed to, my lord, furnish security. If my lord now kindly takes my application, my lord, I have annexed, my lord, statement of accounts. I have annexed balance statements. I have issued a demand notice. Kindly sees the reply that they were talking about, page number 112 of my application.
Yes.
Kindly takes annexure F, my lord, at page 112 of the application. My lord, this is the letter, my lord. This is a clear admission, my lord, and they have also stated that they have not given an undertaking that they are not going to transfer their properties. We are in receipt of your aforesaid letter of demand calling upon us to pay a sum of rupees such and such, 25 crores 88 lakhs 22,596 within a period of 7 days from the date of receipt of such demand notice. My lord, will kindly take the last sentence of that paragraph. We acknowledge receipt of such financial accommodation and also confirm that the said amount demanded in your notice dated 5th of January 2024. My lord will now take the last paragraph of that reply. In view of the above, we are not in a position to repay the aforesaid amount of rupees 25 crore 88 lakhs such and such within a period of 7 days as demanded in your notice, and as such we request you to provide us 4 to 5 months time to repay the and or liquidate your dues. My lord, will see the reply is dated 10th of January 2024. My lord, we gave them that time, my lord, and the next demand notice at page 114, my lord, will see after 6 months. My lord, they did not pay. We filed the suit for recovery of money, and my lord, we have prayed for my lord, attachment before judgment of the properties. Now, my lord, will kindly take 2 paragraphs that I have to show from the application. At paragraph 22 at page 11, I have stated, my lord, that the plaintiff petitioner states that the assets of the defendant respondent mentioned in the schedule herein under is around rupees 20 crore approximately. I had to state the value, my lord. This is where I have stated. And my lord will see that the properties, my lord, the schedule of the properties are mentioned in paragraph number, in page number 14 to 16.
They are having the 20 crore. And
My lord,
your claim is 25 crore.
My lord, 25 crores. The value of the property is 20 crores. I couldn't find any other property that belonged to them, my lord. Now, they have not disputed that. They say they want to file an affidavit in opposition. But clearly, my lord, there is...
Scheduled properties, my lord, the title deeds are lying with them. I cannot sell it.
What title deed?
All the
My lord,
title
they had-
deeds regard about all the scheduled properties that are annexed to the petition or annexed to the plaint. They are lying with them as a security. I cannot sell it.
My
Order
lord,
30 Rule 5, my lord, postulates a situation, my lord, your lordship is aware, that I am either about to dispose of the whole or in part of the properties that I own. Now, my lord, at the time of taking the loan, it is a plain case also, that I had to give all the title deeds to the defendant, to the plaintiff, in order to secure that 25 or 20 crores or amount of rupees to pay off the bankers.
Yes.
Now, my lord, since I am, my lord, may I read out, my lord, Order 38, Rule 5, the first sub-rule, where at any stage of a suit, the court is satisfied by affidavit or otherwise the defendant with intent to obstruct or delay the execution of any decree that may be passed against him, is about to dispose of the whole or any part of his property, or is about to remove the whole or any part of his property from the local limits of the jurisdiction of this court. Now, my lord, My respectful submission, very short response, my lord. I will not be able to sell it. Without title deeds, nobody is going to buy it. There is no case made out by the plaintiff saying that I am actually putting it up for sale or I'm talking to somebody. No pleadings so far as these factual aspects are concerned. My lord, now I leave it to your lordship. My lord. I really cannot say because my clients are not able to pay off, my lord. So I really do not have, my lord.
My lord, just three submissions, my lord. Number one, no undertaking given in the affidavit saying that they are not going to. My lord, in paragraph 6, they have stated that if they intend to dispose of the property, will pay off the dues.
Yes.
And my lord, I wanted to rely on a judgment, my lord, where kindly considers the judgment reported in my lord 2000 SSC Online Madras page 1049, paragraph numbers 27, 28 onwards. Kindly sees, my lord, once. Which specifically states that if no undertaking is given, that they were not going to sell off the properties, my lord, the property ought to be attached. My lord, will kindly see paragraph 28 when it is specifically a word in the affidavit that the defendant intends to alienate the petition mentioned properly only with an intention to delay the execution of the decree that may be passed against him. It is for the defendant to establish that there is no such attempt for alienation. The very fact that the defendant has failed to give at least an undertaking in this counter affidavit that he would not alienate the petition mentioned in property and failed to comply with the orders of the court dated such and such directing the defendant to furnish security for the suit claimed within 4 weeks from the date, we would clearly show that unless
Next.
My lord, there is another I was apprehending that they would say that the properties which we seek to attach, my lord, are situated outside the jurisdiction of the court. If jurisdiction was an obstruction, my lord, I would actually like to rely on, my lord, section 136 of the Code of Civil Procedure, which permits the court, my lord, whether in execution or under Order 38 Rule 5, to, my lord, attach properties beyond the jurisdiction. There are judgments also. If my lord wants, I can cite the judgments. আমার soft copies. And my lord will kindly see paragraph 6 of their affidavit. My thrust of the argument is on
Yes,
that.
I got it. Who are you? You are the finance company.
No, my lord.
Oh.
My lord, I had a relationship with him, my lord. He had, my lord, kindly takes my application. The defendant number 4 obtained loan facilities from various financial institutions and was in a distressful situation. My lord, I have annexed an agreement, my lord, which is at page 20, my lord. My lord will kindly see page number 21, the last recital.
So and so appearing for the plaintiff, so and so appearing for the defendant. The defendant, in terms of the order passed by this court dated 12th of February 2025, the defendant has filed the so cause, stating that in the event if the properties of the defendant are disposed of, the same shall be put into use to clear off the dues of the plaintiff. In the said so cause, it is also mentioned that the defendant never had any intention to deceive the plaintiff, and it was only due to the acute financial crunch faced by the defendant, which is continuing till date, and the defendant is unable to pay off the dues of the plaintiff at present. In the said so cause, it was also mentioned that the defendant has all bona fide intention to pay off all the dues of the plaintiff. So, counsel for the plaintiff submitted, as per the request and as per the relationship between the plaintiff and the defendant, the plaintiff has lent an advance amount of rupees 25 lakhs 88,000
25 crores
88 lakhs 22,596 to the defendant. Full stop. After receipt of the said amount, the defendant failed to return the said amount. Accordingly,
we issued a demand notice which starts at page 97.
Accordingly, the plaintiff had issued a demand notice to the defendant.
Page 97, 5th of January 2024.
To the defendant on 5th of January 2024, calling upon the defendant to pay the said amount.
Reply at page 112.
pay the said amount within 7 days from the date of receipt of the notice. In receipt of the said notice, the defendant had sent a reply dated 10th of January 2024, wherein the defendant has stated that wherein the defendant has not denied with regard to the claim of the plaintiff. And on the other end, it was mentioned that the defendants are not in a position to repay the aforesaid amount of rupees 25,88, 22, 596 within a period of 7 days as demanded by the plaintiff. And as such, the defendant requested to provide 4 to 5 months to repay the said amount. After the period of 4 to 5 months as requested by the defendant, the plaintiff had again sent a notice dated
8th of June
2024,
page 114,
calling upon the defendant for payment of the said amount. But on receipt of the said notice, the defendant has not sent any, neither sent the reply.
My lord, no reply was sent to
He has
this, my
neither
lord.
sent
We
any
filed the
reply
suit
to
thereof.
the said notice, nor had paid the amount due to the plaintiff. Accordingly, the plaintiff has filed the present suit for recovery of the said amount along with the present application for praying for security, furnishing security by the defendant to the tune of rupees 25,88, 22, 596. Full stop. Then the matter was moved before this court. This court is of the view that so-called notice is to be issued before passing any order. Accordingly, the so-called notice was issued and the defendant has filed the so-called reply. Full stop. In the so-called reply, the defendant has not denied with regard to the payment of the said amount, not denied with regard to the demand of the plaintiff. But the defendant has taken the plea that the defendant is not having, and the financial condition of the defendant is not good, and it is not, and the defendant is not in a position to pay the said amount at present. Full stop. Counsel for the plaintiff has relied upon the judgment in the case of Pradeep D. Kothari versus Seat Financial Service Limited, reported in 2000 SCC Online Madras 1049, and submitted that though the defendant has filed the SOCOS but has not given any undertaking that they will not alienate the property and they will comply and they will return the said amount. Police counsel for the plaintiff submit that as the defendant has not made any undertaking in the SOCOS notice, SOCOS reply that they will not alienate the property, but on the other hand, the defendant has mentioned in the paragraph 6 that even if the properties of the defendant are disposed of, the same shall be put into use to clear the dues of the plaintiff. Counsel for the plaintiff submitted from the said statement. And the said statement made by the defendant in paragraph 6 in the SOCOS notice clearly shows that the defendant intention of the defendant will sell the said property. Fully so. Consider the submission fully so. Counsel for the defendant submit that. Counsel for the defendant submit that all the deeds of the property is with the plaintiff as the security. And as such, unless and until the original deed is in the hand of the defendant, the defendant will not be in a position to sell the said property. And as such, the apprehension of the plaintiff that the defendant is going to sell the property, alienate the property, is only the assertion. It is not possible for the defendant to sell the said property without the original document which is lying with the plaintiff. Considering the submission made by the counsel for the respective parties, this court is of the view that before passing any further order, the defendant is directed to file affidavit of assets showing their assets as on date and the value of the assets within a period of 1 week from date.
But 1 week would be.
May I also make one submission, my lord? The show cause was issued as to why he should not furnish security. There is no satisfactory answer, my lord. He should also be directed to.
That's why I'm asking, calling for the affidavit.
My lord, I'm extremely grateful to my lord.
কি বলছে Within 2 weeks, Kalatan. Within 2 weeks from date. List the matter on 27th of March 2025.
Would it be Lordship's pleasure to keep it in the month of April, my lord?
2nd April 2025 for filing affidavit of assets by the defendant.
Grateful. Grateful.
My lord knows that even without the original title deed, one go and lodge a complaint, and my lord,
That's
one
why
can
let-
sell off, my lord.
let the
Just saying. I'm grateful to my lord.
Grateful.
For the petition in this matter,
My lord, I appear for the caveatrix. My lord had directed me to take steps. My lord, an application,
will
my lord, for
kindly see your
extension has
lordship,
been filed, my lord.
Yes.
Yes.
My lord, an application for extension of time, my lord. I have filed it. My lord, this is not appearing in today's list, however.
May
My lord-
I submit two things, my lord?
Yes.
Your lordship will kindly take your lordship's order February 17, 2025 once.
Yes.
Here, my lord, Mr. Banerjee, appear Rohibad Banerjee, concerned appealing for the petitioner. So, my lord, your lordship has considered the aspect of Rule 25, which is the 8-day rule, but your lordship said that difficulty, that's absolutely, my lord, that because of a fault of an advocate, petitioners. But, my lord, here, your lordship has said that appropriate steps should be taken by the proposed
That's
giving.
one opportunity is given.
An opportunity your lordship gave. What steps did they take? They filed a GA2 application. They could have come up before your lordship and filed the affidavit in support of caveat because they've already filed the caveat. Caveat has been filed by them.
My lord, that
Caveat was
application-
filed on 17/5/2024.
Where is your caveat?
My lord,
And
my
when the delay in filing the caveat, where is the caveat?
lord, that
Where is your caveat? Affidavit in support of caveat.
My lord, it is but ready, my lord. It shall, if my lord grants me leave, my lord, I shall file it by today or tomorrow,
This
my lord.
application, I am not
My lord
contesting.
allows me to, my lord, place, my lord, the reason as to why this,
No
my lord,
reason,
the affidavit, my
nothing.
lord.
Once the court has granted 1 week time, you could have been taken the
My lord, the caveat, my lord, the affidavit in support of caveat, my lord, could not have been filed, my lord, without the application, my lord.
what application?
My lord, for extension of time to file the affidavit in support of
Ah.
caveat. My lord, my lord, after this 8-day period has expired, my lord, my lord, for fault of my advocate or whatever fault, my lord, as my lord, I recollect, my lord, I had stated, my lord, the report, my lord, the registrar's notice, my lord, had not been received by me. My lord,
That all are you
my lord, that-
considered and given time
yes,
to
my
you,
lord.
sir.
My lord, even despite that, my lord, if after my lord I had gone to my lord, the department to file an affidavit in support, my lord, I had been stated, my lord, I have been informed that without an application to extend the time, my lord, to file affidavit in support of caveat,
Your
that cannot
affidavit
be
in support of caveat is ready?
my lord, it is ready, my lord. It needs to
Ready?
be affirmed and filed, my lord.
Ready or not?
My lord, otherwise ready, my lord.
What otherwise? Show me.
My
Where
lord,
is
it
all
is-
your affidavit of caveat? Affidavit
My
in
lord,
support
it
of
is not
caveat.
with the advocate, my lord.
That's why you come with the affidavit of caveat by
My lord, if it
tomorrow.
keeps, my lord, yes, my lord, I shall do that.
Not today.
Only one thing, my lord, GA1 application. I have a very innocuous prayer for recording a death.
My lord, of my mother.
Come tomorrow. Let us
Much, very well.
Grateful, my lord.
come with the affidavit of
Yes, my
caveat
lord, I shall
tomorrow.
do that.
51. Yes. कौन है कोई नहीं है pending grant debtors administration.
This is an application which has been taken out in a PLA. PLA, my lord, I must say the scrutiny is yet to be complete, my lord. That can go. But the reason why we are troubling your lordship is this application is, my lord, I am, my lord, under section 235 of the Indian Succession Act. That I am a residuary or universal legatee.
You are the petitioner.
Yes.
And you have filed this application.
Yes.
For appointing the special officer.
Yes, yes. When a petitioner is a universal or residuary legatee, I am the residual legatee, my lord. I have, my lord, that's the subject matter of PLA. I am only asking, my lord, in terms of prayer A, lord, there are some obligations of the estate, my lord, whether I'll get the probate or not as the residuary legatee, my lord, that's the subject matter of PLA. As of now, my lord, only appoint me as a special officer. I'll maintain accounts to, my lord, incur certain expenses and, my lord, other obligations, my lord, connecting to the estate, which we have, my lord, stated in the petition itself. Lord, if Lordship is pleased to come to that kindly come to page 3, my lord.
But the notice, the citation is to be issued. Citation is to be issued.
My lord, this is, my lord, kindly have a look at section 235.
Correct, that are you gone through. Until a citation has been issued to the and published in the manner herein after mentioned, calling to next kin of to accept the refusal.
My lord, so far as all the legatees are concerned, the consent affidavits are there. But my lord, yes, citation is concerned, my lord, I don't citation hoy nahi tha.
No, 235 में residuary legatee doesn't.
Lord, one interpretation is, my lord, that this is since this is an application by the residuary legatee, Lordship will see, my lord, 235 whether citation would be required or not.
Shall not be granted to any legatee other than the universal or residuary legatee.
So
Unless the
if it is a residuary legatee, for all others, the citation is.
No, no. Letters of administration with or will with the will annex shall not be granted to any legatee other than the universal or resident until a citation has been issued. Yes. Where is the PLA? PLA is not here.
PLA is also annexed with the GA1.
How many legal heirs?
The legal heirs are
Daughter has expired.
at page 9 of
Two.
the page 9 of GA1.
2 granddaughters.
But they have been specifically excluded in the will.
2 granddaughters, but when I must indicate they have been specifically excluded in the will. But of course, when at citation, my lord, they are entitled to. I can't say that.
Now, whether they have given
But only
consent.
thing is, my lord, 235, Lordship will see. No, my lord, they have not been issued.
Legatees have given consent.
See the question. Question is being asked whether citation has been issued to all the heirs or not.
And they have come with the consent. They have given the consent. These 2
Grandchildren,
granddaughters.
no, my lord. They are not
Gra-
the legatees in the will.
Legatees have given consent, my lord, but I must be candid. So far as they are concerned, the grandchildren, my lord, who are otherwise an intestate heir, consent is not.
What are the properties? What administration you wanted to?
My lord, as of now, I am only asking. my lord,
Urgency. What is the urgency?
urgency is, my lord, if Lordship kindly comes to page 3, paragraphs 8, 9, and 10. 8 and 9. Well, there are some income tax payments which are to be done, and my lord, for the financial year. That's all. My lord, I'll keep separate accounts, my lord. That shouldn't be a problem. And then, my lord, after the scrutiny is complete, citation and all that, all these have to be done.
That we thought that can satisfy. So that amount that tax invoice to the Kedago. All these tax invoices are being placed on me for maintenance. Includes things like electricity bills.
And my lord, the estate also has, my lord, bills being raised, my lord, on maintenance charges and electricity charges, page 109 onwards, electricity bills and others, so far as the flats are concerned and offices are concerned of the deceased. But those also, my lord, I need permission to pay.
Call option.
Yes.
Lordship will appoint, my lord, me as an officer of court, my lord, I will be liable to keep separate accounts. So that, my lord, in the event, my lord, there is otherwise Lordship comes to any other conclusion, my lord, as an officer of court, my lord, money if I have spent otherwise, my lord, I shall be liable.
So and so bring for the petitioner. The petitioner has filed the present application being GA1 of 2025, praying for appointing the petitioner as a special officer to meet the obligations of the state and to make due payment from time to time and all its expenses and liabilities out of the estate of the properties. Estate and properties. Please, counsel for the petitioner submitted. The petitioner has filed the present application, filed an application being PLA 29 of 2025, praying for grant of letters of administration to the last will and testament dated 21st of April 2017 toward the properties and credits of Manjushri Khaitan. Manjushri Khaitan, full stop. Counsel for the petition submitted. The testatrix has executed her last will and testament dated 21st of April 2017 by appointing the petitioner as universal legatee of her last will and testament. Full stop. Counsel for the petition submit that the petitioner is also one of the trustee.
Yes.
Trust. Petitioner is also one of the trustee of
One of the trustees of the residuary
of
legatee.
the
The
Manjushri
trust who is the
Manjushri
residuary legatee.
Khaitan Employee Benefit Trust and the residuary legatee full stop. Counsel for the petitioner submit that the bank account of the deceased has become inoperative after the death of the deceased, and for further opening of the new bank account in the name of the estate of the deceased, a new PAN card is required to be issued in the name of the estate of Manjushri Khaitan. An application needs to be made in regard to the income tax authority or through the Protein e-Gotin website center, which can be done only after the appropriate order passed by this court. Counsel for the petition submit that it is incumbent upon the applicant that the estate of the deceased to be render payment for sum of rupees 1.24 crore to the income tax authorities for the assessment year 24-25. He submit that the petitioner has received an email dated 17 February 2025 from the chartered accountant of the deceased as a reminder for filing of income tax return of the deceased for the assessment year 24-25. Full stop. 2025 for making the said payment. Counsel for the plaintiff submitted if the petitioner is appointed as a special officer only to meet the obligation of the states and to make the due payment from time to time of all its expenses and liabilities out of the estate of the assets and the properties of the deceased, the petitioner will maintain a separate account and will furnish before this court as and when required by this court. Counsel for the consider the submission made by the counsel for the petitioner. This court find that the petitioner is being the universal legatee and also the
Being a residuary legatee.
Residuary legatee and also the one of the trustee of the Manjushri Khaitan Employees Benefit Trust, and he has received the notices from the chartered accountant for payment of the income tax return for the year 24-25 and also required to pay all other dues to the concerned authorities, that is the municipal corporation is there to the
primarily income tax, and my lord, there are maintenance charges to the flat owners as well.
All notices from.
That is with regard to the maintenance charges of the several flats. Considering the above, this could find that that the petitioner can be appointed as a special officer only for the purpose of to meet the obligation of the state and to make due payment from time to time to all the expenses and liabilities out of the state assets and the properties. properties. Full stop. The petitioner is appointed as special officer only for the purpose of to meet obligations of the state and to make due payment to the concerned authority, including the income tax authorities, and to maintain a proper account which the petitioner, being a special officer, has invested for payment of dues of the estate of the deceased. Full stop. Estate of the deceased. The petitioner is directed to file the accounts every 3 months, every 6 months, every 6 months. Full stop. ये pending रहने तो उस लोग आएगा फिर देखेगा.
But GA can be disposed of. PLA after scrutiny will come in.
But
its
if the other party will come, then the GA.
Very well. Well, let it remain.
Let it be.
Let it remain.
Because without notice it is.
Very well. Very well. In the meantime, the scrutiny and the other formalities.
That will done.
Very well.
That the office will do now. Right.
On the last occasion, my lord, your lordship had indicated me, find out, my lord, which bank account number the locker is connected to, my lord. Only on that point, my lord, it got stuck on the last occasion. So, my lord, kindly takes the affidavit of assets, which is at 110. But
that is 111 locker number, no?
Correct. Now,
572.
Yes, my lord.
572.
Now that is connected to your lordship. If your lordship takes page 109, my lord, item B, 1B, there is a bank account. My lord, it's connected to that, and my lord, I've got the document showing that, my lord. Kindly have a look at this.
Item B.
Yes, my lord. Item B,
Bank
with
balance
Indian
with
Bank.
Indian Bank.
Correct. That's the bank account. It's related to, my lord.
Indian Bank.
Your lordship sees the account number 479405344.
That is a new account.
Yes,
but can't you see the address? 110 and 111.
111.
And here is the 110.
Yes.
Thank you.
No, ekhane. And it will be 111 only. Correct. Your lordship is absolutely correct. It will be 111. My lord, and the other one was, my lord, with regard to that, my lord, apartment number being incorrect. And my lord, the other prayer which I was seeking is, my lord, which is more important, my lord, is prayer C actually. My lord, we are willing to, my lord, we have communicated with the Bengal Unitech to basically that we'll give them all the charges, holding charges and whatever. At least the conveyance needs to be executed. Because if they don't, possession also needs to be given, and that conveyance also has to be executed in the name of the applicant as administratrix to the estate. Because only half.
Execute and register conveyance deed in the name of the applicant as an administratrix to the estate of so and the share. It is required to the deed is required.
Yes,
there is in the society there is no.
No, my lord. This is not a cooperative society. My lord, that share certificate, that's only in the cooperative society.
That's what I'm telling.
No, my lord.
So it is the change of the ownership.
Yes, this is basically something was constructed, he had booked the flat, half owner, my lord. There is an agreement which I had shown to your lordship on the last day.
And where is the probate? When the probate was granted?
My lord, I'll give your lordship the
Letters
date.
of administration.
Yeah.
That is on 5th of January.
Yes, my lord. There's a order also to that effect which is granted.
So and so approving for the petitioner. Concept for the petition submitted by an order dated 5th of January 2023. This court has granted letters of administration. Has granted letters of administration. Full stop. After the grant of letters of administration, the petitioner has found for the two property, that is half share in the apartment number 1203 on the 12th floor, tower 2, having a super area of 2041 square feet, along with 2 car parking spaces in the gardens at Uniworld City, Kolkata, West Bengal, 700156, and locker being locker number 572 with the Indian Bank, Lake Road branch, 111 111, Southern Avenue, Hemanta Mukherjee Sarani, Lake Terrace, Waliganj, Kolkata 700029, connected with the account number SB-6614, then within bracket 47940534. So for the plaintiff, praise for amendment in the affidavit of assets. The counsel for the plaintiff further submit that the petition is also entitled to get the deed registered through the Bengal Unitech Universal Infrastructure Private Limited, and as such he prays for a direction upon the said party to hand over possession of the said plot and to execute the conveyance deed in favor of the petitioner. Consider the submission made by the counsel for the petitioner. This court find that the amendment as sought for by the petitioner is formal in nature and is necessary for the purpose of administration of the property of the deceased. Accordingly, this court also find that the petition is also entitled to get the what is the flat number? You're not given this.
Not given.
No, C, prayer C.
Let's see.
Direction given Bengal Unitech to hand over the possession of the flat. What is the flat number? You're not given that.
Your lordship can say as indicated, my lord, in the affidavit of assets, my lord, which is at page 110, my lord, flat number is there.
Which one? This which has been affected? This is a amendment?
Yes.
Amendment?
Yes, my lord. This half share in apartment number 120.
Get the above mentioned flat recorded in her name and to get the possession of the property, get the possession of the said flat accordingly. Full stop. In view of the above, the prayer A2, prayer D of the master summon is allowed. GA 1 of 2025 is disposed of. Full stop. In the amended portion of the affidavit of asset, at page number 111, the number of the bank, the number is to be recorded as 111 instead of 110.
The address
Address of the bank shall be read as 111 instead of 110.
Grateful. This is one person we miss in the profession on a regular basis. But he was definitely, my lord, a true representation for the entire, my lord, juniors and everybody. Grateful. I'm sure, my lord, your lordship must have had me.
It is for all over India. He was a speaker also.
That was, my lord, his father.
His father, that's why
Yes.
that carried.
The grandfather, my
That
lord.
carried.
I am appearing on behalf of the petitioner, your lordship.
Yes. Liberty to mention what has happened.
Your lordship.
Issue upon the attesting witness, namely so and so, and the pronoun. Yes, notice issued.
Yes, notice issued. It has reached. The mode of service is at page 13, your lordship. One of the attesting witnesses had passed away. The death certificate we were finally able to get.
Where from you reading?
In the application, your lordship.
Application hai kya?
Application
J1.
J1, your lordship.
Yes, page.
Page 13 is the mode of service. 12 and 13.
12 and 13.
The mode of service in page 12, the named attesting witness, he is alive. He is alive.
Who?
The one named in page 12, your lordship.
Page 12, Pranab Kumar Datto.
Yes.
Yes.
He is alive. He has come forward. He wants to submit the affidavit of the attesting witness.
Have you
Page-
submitted?
Your lordship, I have made, yes, your lordship, it has been prepared. It is made ready and affirmed, your lordship. Upon your lordship granting leave, we can file it. The second attesting witness, your lordship, the mode of service is at page 13 and the death certificate is at page 14, your lordship.
2014. He died on 14.
Yes, we have filed in 2021.
What is the date of the will?
The will is
बाबू, ये will चलेगा आपका?
4th December 2000.
Your will say.
My God.
That is. How you will get the probate of this will?
Your lordship.
I find here the will is the document which carries years together. And you all persons are filing this as per the advice of the office as enclosure. It should be in this locker.
Your lordship.
With the lamination.
Your lordship.
If the person is filing the will, disclosing the original will in the original side, you have to disclose the original will.
Yes.
It has to be either in the lamination form or in the locker. You have
Yes,
to provide one small box with that, with the key. One key will be in the department, one key will be the U, and at the time of evidence, it will be open and the original document will be bring out. Otherwise, the will is open lying with the all persons. I don't know what is going on. How the procedure has been adopted. This is not the way.
I appreciate what has fallen from your lordship.
And if tomorrow the probate will be granted, what you will do with this will? How you will prove this?
That is.
There's something, do something, otherwise it will go. I don't
Yes,
think.
yes, your lordship, we will take steps. for
So
that
you
immediately.
persons are filing the application in the A4 and this wills and all the board documents are in the legal size. Yes.
Hold. Now, your lordship, we are only seeking to amend the probate of application for grant of probate, your lordship, since we had originally filed stating that both of them had passed away because the executor had himself inquired during the COVID period. It was from the two houses. He was told that both of them had passed away, but now it seems that one
You
had
want to
now.
amend this?
Yes,
You file the amendment.
yes, your lordship. The proposed
J1
amendment. Yes, your
J1 is there.
yes, your lordship. The proposed amendment is at page 21.
Where is the proposed amendment?
Your lordship, page 24 and page 25, your lordship.
And what was the earlier? 7A. So you mentioned both are tied. Where is that? You
Your lordship.
mentioned in the probate application both the attesting witness died.
Yes, your lordship.
Which
Para
paragraph?
5, your lordship, at page 24 of my application only in the
So you want
proposed
to
amendment.
delete this.
Yes, to delete this.
The attesting witness name is not. You have to add this facts. After the order of the court, you have issued the notice, and after the notice, you came to know one died, one is present, and he came forward and executed
Your
the
lordship,
affidavit.
that I have mentioned everything in the application, your lordship.
Not application. This fact has to be brought here. Okay.
That is.
So appearing for the petitioner. The petitioner has filed an application being J1 of 2025, praying for amendment in the probate application. Counsel for the petitioner submit that. After the order passed by this court, notices were issued to the attesting witnesses of the will. After the issuance of the notice, one of the attesting witness, namely Jadab Kumar Malik, has received the said notice.
Your Lordship, he had passed away. Page 12 is the person who is alive.
Pranab Kumar Datta has received the notice and has come forward to file an affidavit stating the fact that the testator has executed his last will and testament in his presence and in presence of the another attesting witness. But with regard to the another attesting witness, after issuance of the notice, it has come to the notice that the said attesting witness, namely Jadab Kumar Malik, expired on 21 June 2014. 21st June 2014. Counsel for the plaintiff prays for amendment in the probate application and also to file the affidavit of the attesting witness, namely Pranab Kumar Datta. Consider the submission made by the counsel for the petitioner. This court finds that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the present application. Accordingly, prayer A to D of the master summary is allowed. GA1 is disposed.
Your Lordship is fixing any time to re-verify.
Not given.
No, Your Lordship.
The department is directed to complete the amendment as proposed by the petitioner within 3 weeks from date. And after the amendment is carried out, the petitioner is given liberty to re-verify and reaffirm the same within a week thereafter.
May it please your Lordship, I am appearing on behalf of the applicant petitioner Miller in this application for revocation of grant of probate.
Kindly
But
take
before
order
I
dated
begin,
26th
Miller,
of February.
26th of
court has
February,
been taken for a
26th
ride.
of February, Miller, your Lordship was pleased to restore this application upon payment of cost of rupees 10,000 to be paid within 7 days. That took us to 5th of March. We couldn't do it. We approached your Lordship, Miller, and we mentioned the matter. Your Lordship was pleased, Miller, to take up, and 12th was the date already fixed. We are carrying, Miller, the amount of cost. Yeah, we are carrying, Miller, the amount of cost which we can hand it over here and now.
Lord, on
May I
at least
proceed?
10 to 15 occasions, Lord, this matter has been taken up. In last year, August, they were directed to Lord, serve Lord, a reply against this petition. Lord, nothing has been done till date. Lord, 8th of January, this matter was taken up, they did not appear. Lord, so long they kept Lord absent. Lord, on 8th of January, they didn't appear. Your Lordship wanted them to give a further opportunity. Finally, on 22nd of January, when they did not appear, it was dismissed for default. Now, Lord, on the last occasion they came up, Lord, I did not oppose, Lord, because these kind of applications I usually don't oppose. Lord, your Lordship fixed a term. Again, Lord, the same conduct continues.
So now
But
what
at
is the
some
stage?
point
What is
of
the stage?
Affidavits have been exchanged, Milord. I have, Milord, foregone my right to file my affidavit in reply pursuant to the dismissal order. My cost is ready. If I am being permitted, Milord, to hand over the cost, I can move my application here and now.
What application?
Application for revocation of a grant of probate, which was, Milord, granted in 2023, Milord.
Not kindly goes through order dated Milord February 26.
Yes.
But your Lordship would find the entire conduct, how they have been conducted.
Correct.
Repeatedly, Milord, they are
7 days took us to 5th of March. Milord, we mentioned the matter before your Lordship that we were unable to pay it within
Lord,
7.
a defaulter when coming to court, at least the last date which has been fixed by the court, Lord, that should be honored.
The 12th, the matter was fixed. Yes,
but
Milord.
kindly see the penalty made paragraph. It is
Yes.
made clear that if the applicant failed to pay the cost, the
Yes.
order will be
Milord,
revived.
we had mentioned the matter before
And
your
the order
Lordship.
dated 22nd January will remain
Lord,
uninstalled.
nothing was,
Milord,
never it
on
was mentioned.
7th we approached.
Never it was mentioned.
And we, no. Your
Yesterday-
learned advocate on record
yesterday-
was there.
Lord, I was also
It was mentioned.
Yesterday a
Milord,
notice was
and
given.
your Lordship said that matter
Yesterday
is
a
fixed
notice was
today.
given in the morning, it will
I'm
be
carrying
mentioned.
the cost,
I was
Milord.
personally there. Lord, nobody mentioned it.
Milord, I'm carrying the cost. Citation has not been
That
served on my client, which is apparent from record.
26 February, a week time was 10 days time. What
That takes us to 5th of March. Milord, today
Correct.
we are on 12th of March.
Probate granted in March 23. They were lying in the slumber.
Milord, I'm not, Milord, my Pivotal ground is citation not served. That's on merit. I'll show it from their records, my lord. That is what I will show your lordship. Kindly allow me, my lord, to hand over the cost which I am carrying here and now.
But that cost, my lord, I think, my lord. And it's my lord, kindly sees the observation. at the last
Otherwise,
page,
my lord,
my lord,
a
it's
probate which has
basically
been granted
modified now.
without citing me.
But you're not fine because how this court can allow the last paragraph?
Yes, my lord.
Kindly go page 4.
Yes.
Page 4. The court cannot.
My lord, kindly allows me to. His
What
lordship's
allow?
order.
No, sir.
Your lordship's order, my lord.
Sorry. I have given a detailed order why I am giving you, but you missed the chance. What the time and again it cannot be done, sir. Sorry.
My lord, we approached the learned advocate on 7th. My lord, I don't expect this from my learned friend.
What can be done?
Just
This is your
2 days, my lord, which has happened. On 7th, we approached. They did not accept it.
The court has
And I am
given-
now today before your
you missed
lordship.
the chance, sir. You missed
My lord,
the
on
bus.
the merit, my lord, I have a case which is appreciable.
Maybe,
in
but
my
what can be done? If the merit, but you're not diligence to carry out the order, this application, so what can be done? This was dismissed, then this
And
court
my
has
lord,
allowed,
my right to file
and
my
the court has
reply was
allowed
also
with the
forfeited.
cost,
My lord, I-
some time was given, you're not paid, and then the penalty made paragraph, the court cannot so much to recall that.
It talks about default. I've
My
been
lord, kindly
accommodating it
appreciate,
for
my lord.
last 1 year.
My lord, kindly appreciate one thing, my lord. I am the applicant, my lord. And my lord,
Maybe.
I am, my lord, the daughter-in-law.
Correct.
Citation has not been served on me.
Sir,
It is
that
apparent.
is I am,
On merit, I
this
have a
court
very
is not going into the merit.
This is just, my lord,
I
an affair of
heard you
case
on the
which is-
last occasion. Yes, this court find that one opportunity should be given. After hearing you, this court has given an opportunity subject to payment of cost of rupees 10,000 within a week from date. But you failed to comply with the order. That is and that's why this court knows that it will happen. That's why the
My lord, I am aware, my lord.
penultimate
My lord, I am aware-
paragraph has been
aware, my
given.
lord, of your
That
lordship.
penultimate paragraph, if I
It
this
is very
court
serious, my
himself,
lord. It ought to have been followed.
that this court itself
ought to have
can
been
violate the order of the can
my lord,
modify this.
My lord, it ought to have been followed. And this is, my lord, which I have also informed my learned juniors in this matter, that these orders, especially before your lordship, is very serious about orders which your lordship passes. And this has not been followed. I bow down, my lord. But my lord,
Sorry,
in
Mr.
this course,
Banerjee,
my lord,
come with other matter with the
your lordship will kindly,
good
my lord,
cause. This is not.
my lord, on merit, there is an appreciable case.
No, can't. Penultimate paragraph, this court can't. Sorry.
No, my lord,
Otherwise, the penultimate paragraph would not have been there, then this could have been think that.
But I'm being obstructed, my lord, from reaching the merit just because, yes, this penultimate paragraph, my lord, is very clearing and ought to have been followed in all fairness, my lord.
Suffering for the applicant, suffering for the executrix.
My lord,
By
if your
an
lordship imposes further cost, my lord,
No.
can we please, my lord,
By
if your
an order
lordship's
dated
auspice,
26th of February 2025.
proceed with the matter, my lord.
The court order cannot be valued through the cost, sir.
My lord, that is certainly.
क्या बोला? By an order dated 26 February 2025, this court has allowed disposed of GA3 of 2025 by restoring the GA2 of 2024 in its original file by recalling the order dated 12th by recalling the order dated 22nd January.
No, 22nd January.
Yes, by recalling the order dated 22nd January 2025, subject to payment of cost of rupees 10,000 by the petitioner, by the applicant to the executrix within a week from date. In the said order, it is also made clear that if the applicant fails to pay the cost, this order will be revived and the order dated 22nd January 2025 will remain stand. Full stop. Counsel for the applicant admit that the applicant could not pay the cost of rupees 10,000 within a week from date. He submitted the amount is ready today and he will pay in the court itself.
And my lord, we had approached them on 7th of March.
Counsel for the plaintiff submitted, applicant submitted. The counsel for the applicant has approached the learned counsel for the executrix on 7th of March 2025, but they have not accepted the said amount. This court find that the order is passed on 26th of February 2025, giving 1 week time to the applicant to pay the cost within a week from date. 1 week has over on 5th of
5th
March.
of March.
5th of March 2025. But the applicant has not paid the said amount. He has approached the executives on 7th of March. That is also the after a 1 week. Considering the above, this court find that the petitioner is not diligent and the applicant is not diligent to pursue with the matter. In spite of the opportunity given to the applicant failed to comply with the order by paying the cost of rupees 10,000 within a week to the executives. Accordingly, the order dated 22nd January 2025 remain stand, and the order dated 26th February 2025 revise.
Oblige. Oblige.
Lordship, I am for the petitioner. In the last occasion, Lordship, in the GA1, Lordship has passed an order on 6th of February to file the affidavit in opposition. And if there is any reply, we have carried our reply here, Lordship. And
My lord,
It
my
is
opposition, my
completed?
lord, yes, my lord, my
Yes.
opposition is ready, my lord. Copy has also been served within time, my lord.
So appearing for the petitioner applicant, so appearing for the executor. Parties have filed their affidavits in terms of the order dated 6 February 2025. Let the same be kept with the record. This is the matter. Ready?
Yes.
This is the matter on. मंगल को आएगा hearing है. That's the matter on 19th March.
Highly obliged, Lordship.
Next.
Lordship, I am appearing for the petitioner. Lordship, this is an application for grant of probate of the will dated 3rd February 2010, Your Lordship. Your Lordship, we had not filed the consent affidavits and therefore we had prayed for issuance of general and special citation upon the heirs, Your Lordship.
Again, see, your bill is going to be shown. Take leave from the court and this laminate.
Lordship.
Otherwise, before the disposal of the case, this will go.
Lordship.
Then you will not be in a position to get the benefit of the will. How many legal years?
Lordship, there are 3 legal
Where
heirs.
it is? 1, 2, and 3.
Lordship, one of
has come.
Lordship,
One is
no.
the executor.
One is the executrix, Your Lordship.
Executrix.
And
Who have not come forward.
no, Your Lordship.
So you want to issue citation?
Lordship. No, Lordship, citation has been issued, Your Lordship.
Ah.
General and special citation both have been issued.
So
We
what
had-
you want?
Lordship, probate in terms of the will dated, Your Lordship, 3rd February
Where
2000.
is the no caveat certificate?
Lordship, we had filed it, Your Lordship. It had come from the
Yeah, no
department.
caveat certificate. Hai.
Your Lordship, on the last occasion, Your Lordship had directed the department to bring on record the affidavit of service, Your Lordship.
हम लोग को रोज अलग अलग ऑर्डर देना पड़ेगा एफिडेविट कैविट सर्टिफिकेट नहीं आएगा. Have you not obtained no caveat certificate?
Your Lordship, we had.
After this publication?
Your Lordship, we had, as per my instructions, we had obtained, Your Lordship. Lordship, may kindly keep it tomorrow, Your Lordship. I'll come back, Your Lordship.
To
In that
consult the
case.
department. Department has to send the no caveat
Yes, Your Lordship.
certificate. You have applied for?
Lordship, as per my instructions, Your Lordship.
Not
we had
today.
applied. Grateful, Your Lordship.
cross, my lord.
Huh?
Yes. We have to resume our cross examination.
आपका नाम बताइए।
मैं आनंद मरोठिया हूँ।
आनंद मरोठिया। Speak slowly. ANAND MAROEHIA.
Mr. Marothia, you have deposed previously that the deceased had gone multiple times for health checkup to Chennai. Can kindly tell the honorable court why was this required if he was in a proper health and mental state?
मैं हिंदी में थोड़ा सा जवाब देना चाहूंगा। हमारे फूफा जी को चेन्नई जाना पड़ा था।
My uncle had to go to Chennai
जस्ट एक सिंपल मेडिकल चेकअप के लिए गए थे। उस
For-
समय ऐसा कोई बहुत
for a simple medical checkup. At that time, there was
कोई बहुत ज्यादा बड़ी बीमारी की उस समय बात नहीं थी।
no big ailment as such at that time.
उषा और दिवाली के पहले जब वो पहला चेकअप करा के आए, बायोप्सी करा के आए,
When he came back after having his biopsy before Puja and Diwali
in 2019, year 2019,
2019,
उस समय पता चला कि उनको कुछ प्रॉब्लम है यूरिनल में, इसलिए वो वहां पे चेन्नई में अपोलो में चेकअप करा के बायोप्सी करा के आए, बट उसका रिजल्ट आया बाद में।
at that time, it came to be known that he had some urinal problem, and that is why he had gone for checkup in the Chennai Apollo Hospital.
Yes.
Are you aware?
My lord, only one thing at the cost of my lord interrupting. My lord, my learned friend's question was that he on his previous answer had said that the deceased had gone multiple times. With due respect, my lord, that answer nowhere appears in the cross-examination. So may it just be with objection. So that, my lord, at the time of argument, this can be argued upon.
That is a matter of record. If it is not, it is not. It's a matter of record.
As your lordship pleases, if your lordship so pleases, we'll keep it, but that has not been the
No problem. It is a matter of record. It is a multiple or not.
Are you aware, Mr. Marothia, exactly how many visits were made by your uncle for health checkup to Chennai during the time you're talking about?
मतलब मैं समझा नहीं, थोड़ा सा हिंदी में बोलेंगे।
बार वो चेन्नई में हेल्थ चेकअप के लिए गए।
मेरे हिसाब से फर्स्ट टाइम था।
It was the first time, as per my knowledge.
Are you aware if any other checkup or any other time he had gone to Chennai for health checkups?
No.
Previously, you had deposed on a multiple times that during the time when the will was executed, your uncle was in a proper and fit health condition and also mental state. For if such is so, if my lord, if I may kindly show him the will and ask a question.
What is the question? First, complete the question.
If
I think
such
question is not
so,
completed.
why does the said alleged will talk about him suffering from terminal illness?
हिंदी में बस बोलेंगे।
वो बता दें। आप बहुत बार
My lord, again, this is subject to objection because this is an opinion that he's seeking from the witness.
No, no,
What,
no.
I'm asking,
why
my
so? That is his.
उनका बोलना है कि आपने बोला ना कि आपका जो है अंकल जो है फिट स्टेटमेंट था, लेकिन उनका बोलना है विल के बारे में तो आपको मालूम है।
यस यस यस।
विल में एक जगह लिखा है कि वो कुछ क्या लिखा है, पढ़ के बताओ।
Suffering from terminal disease.
टर्मिनल डिसीज। तो क्यों लिखा है उनका पूछना है, अगर आप बोलते हैं फिट स्टेट ऑफ
एकदम फिट थे। ये क्यों लिखा है मैं नहीं बोल सकता, बट
मैं
मेरे
नहीं
सामने विल साइन हुई।
yes I cannot say why he has written the said word, but he was fit state of mind.
100% fit.
Why it was written that way, but he was fit.
100% fit, sir. Not fit.
100% fit.
Mr. Marotia,
Yes.
are you aware if during the visit, did the defendant ever accompany your uncle to Chennai?
एक बार हिंदी में फिर से बोलिए।
खुशी टिब्रोवाल कभी आपके अंकल के साथ चेन्नई में गए थे जब वो चेन्नई जाते थे या
यस, 4 नवंबर 2019 को जो चुन्नी जाने का था, हमारे बुआ जी
on 4th November
2019
when he had to visit
विद बुआ जी एंगेज और खुशी,
my
इवन
uncle,
शायद बुआ जी भी शायद
खुशी
सब साथ में गए थे।
my aunt together had gone to कहाँ गए थे?
चेन्नई सब साथ में गए थे।
Chennai.
Ingit.
इंगित also, yes.
Went to Chennai.
Are you aware what all treatment your uncle had to undergo for the said urinary tract illness?
हिंदी में हाँ।
का जो यूरिन में प्रॉब्लम था इसके लिए उनका क्या ट्रीटमेंट हुआ था अपोलो?
जैसा आपको मैंने बताया कि पूजा और दिवाली के पहले वो बायोप्सी करा के आए थे। वो पेट क्या इंग्लिश का वर्ड मुझे याद नहीं है, कुछ यूरिनल में इन्फेक्शन जैसा था जिसको बायोप्सी कराने के बाद वो कैंसर का रूप या क्या एक ठो ऐसा बताया गया, स्टमी पैड या ऐसा कुछ इंग्लिश वर्ड है मुझे नहीं मालूम। बट उसका फिर वो ऑपरेशन करा के बाद में वहां हफ्ते 10 दिन रह के फिर वो आए।
As I had said earlier that he had gone to Apollo Hospital Chennai for treatment of urinal infection.
फाइनली ऑपरेशन के लिए गए थे।
There it was found that he has some problem and it was like cancer.
हाँ, जो बायोप्सी रिपोर्ट जो आया था,
After the obtaining biopsy report, it was found some type of cancer, but I cannot exactly say the English word of the said disease.
Said disease. Thereafter, he had undergone an operation और कुछ
ऑपरेशन शायद 8-9 तारीख का था या ऐसे कुछ था, मुझे पूरा एग्जैक्ट डेट याद ना।
around on 8th or
मे बी
9th.
7, 8, 9 या ऐसे ही कुछ होगा।
Might be on 7th, 8th or 9th. After the operation, he was there for the
2019,
10 days.
November 2019।
2019.
Yes, next.
Were you ever aware that such illness had been cured?
उनका जो वो बीमारी था वो कभी सही हुआ था?
Were you
Are
ever
you aware whether the said deceased was cured?
मेरे को जहाँ बुआ और फुआ जी बताया, जब फर्स्ट टाइम ऑपरेशन करवाने का जो बायोप्सी हुआ था उसी समय डॉक्टर ने शायद बताया था कि नहीं, यू आर कम वेरी लेट, तो अभी आप जो बायोप्सी करा रहे हैं तुरंत ही ऑपरेशन करा लीजिए। बट फूफा जी ने कहा नहीं, मुझे कलकत्ता वापस जाना है, कुछ मेरा बहुत जरूरी
नहीं,
काम
उनका
है।
एक ही सवाल है कि वो बोले ना ऑपरेशन के बाद आपका फूफा जी स्वस्थ हो गए
हाँ
थे?
एकदम एकदम
तो
स्वस्थ
कोई
थे।
आप हाँ या बोल
यस, सारा काम अपने आप ही करते थे, बीच में आके ऑफिस भी जाना चालू किए,
Just only tell
वो
the
ऑफिस
witness
भी
that
गए।
he should go a little slow.
Yes, आप ना सुनिए पहले,
हाँ
आप समझिए, समझ नहीं आता तो पूछिए और वही आंसर दीजिए।
ठीक है सर।
Yes.
और धीरे धीरे बोलिए और लिखना है।
हाँ जी ठीक,
Yes,
एकदम ठीक थे,
he had-
ऑफिस भी जाना चालू कर दिए।
ठीक है, ठीक।
Yes, he was cured and he had started going to the office as told by me from my uncle.
हाँ सूरज जी ऑपरेशन के बाद आए भी थे, ऑफिस भी जाते थे, मैं ऑफिस में मिला भी हूँ।
After operation, he had come and I had met him and he used to go to the
ऑफिस ऑल्सो।
The office. I met him at the office.
Yeah, in December, month of December,
I met him to বলেছি না?
Yes.
Met him in the office করে দাও।
December and January first week, second week also,
In December.
Yes, next.
January first week,
second week also।
second week also.
You have previously deposed that you had also been working or have been in business with your uncle. In such regards, can you tell this honorable court, was your uncle a legally prudent man and knew the various workings of legal documentation.
आपके जो अंकल थे, आप उनके साथ काम करते थे, आपने बताया, तो वो क्या सक्षम आदमी थे? लीगल मैटर्स में उनको समझ में आता था, ये आइन कानून ये सब समझ में आता था?
जी अपना बिजनेस करते थे और मैं अपना बिजनेस करते था, उनके साथ में कोई जॉइंट बिजनेस नहीं था मेरा, बट मैं उनके ऑफिस में बैठ के अपना बिजनेस करता था। मेरा जो
did not have joint business. He used to do his business. I used to look after my business.
बट हमारे फूफा जी हर तरह से सक्षम थे, कानून के हिसाब से, अकाउंट्स के हिसाब से, या किसी भी चीज के लिए वो खुद डिसीजन लेने में बहुत ही अच्छे सक्षम थे, जानकार थे।
Uncle was prudent enough in legal matters, accounting matters, and he used to take his own decisions.
Then, in consideration of your answer, can you tell the Honorable Court why he did not deem it fit to register the said alleged will?
No, not it will not go. Why he has not registered? How he can say?
My lord, I'll reframe it. You have deposed that you reside at 35 V, Roman V, comma, Radha Madhav Garden, Dotto Garden Lane, comma, Beliaghata, Kolkata, 7,10,000. Is it the current place of residence? Is it your current place of residence?
यस, एक चीज और बोलना चाहूंगा, मेरा आधार कार्ड, वोटर कार्ड, पैन कार्ड सब इसी एड्रेस पे है, और एक आई हैव ए वन हाउस एक्स्ट्रा, वो है राजा राजेंद्र लाल मित्रा रोड, वहां अभी मैं रह रहा हूँ।
Witness volunteers.
Yes, volunteers.
My Aadhaar card, PAN card are also having the same address, and I am also having another property at
राजा राजेंद्र लाल मित्रा रोड, 1/1 राजा राजेंद्र रोड,
1/1
that is also
Raja
in Beliaghata.
Record that.
Raja Rajendra
1/1 राजा राजेंद्र लाल मित्रा रोड,
Mitra Road, Beliaghata, Kolkata.
Be presently इसी एड्रेस में रहता हूँ।
And I am presently residing
At this
at
address,
the Raja Rajendra Lal Mitra
Road,
address.
Sri Krishna Garden apartment,
Sri Krishna Garden Apartment.
yeah. Flat number DF5.
Flat number
DF5 ground floor. DF5 ground floor.
Yes, next.
Have you ever accompanied the deceased for any health checkups?
Sorry?
Have you ever accompanied your uncle for any of his health checkups?
आप उनके हेल्थ चेकअप में उनके साथ कभी गए थे? कभी?
नहीं, मैं कहीं नहीं गया, बट अपोलो में जहाँ एडमिट थे वहां देखने के लिए मैं जाता था, बट मेडिकली ट्रीटमेंट के लिए मैं कभी भी उनके साथ में अंदर में नहीं था।
Did not accompany him for any medical checkup, but
for his
medical checkup. But when he was admitted in Apollo Hospital, I had gone there to visit him.
Yeah, regularly.
Regularly.
Mr. Marotia, if he had only gone once, according to your deposition, he had only gone once to Chennai for a health checkup.
where other places he had held checkups for such disease that we had told this learned court, honorable court.
आपका कहना है कि वो एक बार अपोलो में गए थे चेन्नई में और कहीं वो गए थे?
नहीं सर, एक बार नहीं, 2 बार गए थे। एक बार पूजा के पहले जो नॉर्मल चेकअप गए तो उनको पता चला कुछ प्रॉब्लम है तो बायोप्सी करवा के आए। आफ्टर दैट जब पता चला बायोप्सी रिपोर्ट में कि देयर इज सम प्रॉब्लम, बिग प्रॉब्लम, यू हैव टू डू द ऑपरेशन, तब वो सेकंड टाइम गए थे। आपको तो बताया मैंने कि 2 बार गए थे।
He went to Chennai twice.
फर्स्ट बिफोर पूजा के पहले,
For puja,
नॉर्मल चेकअप ये सब के बाद।
he had gone to Chennai for normal checkup. There he had done his biopsy, and there it was found that he has a problem like
a कैंसर,
problem.
उनका ऑपरेशन कराने के लिए सेकंड टाइम
Thereafter,
4
he
नवंबर।
visited Apollo Hospital, Chennai, second time to undergo an operation for the said disease.
After getting biopsy report.
Yes.
Mr. Marotia,
yes,
can you tell the honorable court how was the relation between your uncle and the defendant?
खुशी टिब्रेवाल और आपके अंकल के बीच में उनका संपर्क कैसा था, रिलेशन?
एज ए फादर डॉटर बहुत अच्छा रिलेशन था, जैसा सबका होता है।
Father and daughter, they had good relationship as it is with all.
बट जब वो खुशी हमारे बुआ और फूफा जी के विरुद्ध जाके शादी कर ली, उनको पता न चला कि ये कब लव मैरिज की है नहीं की है, उस समय के बाद से उनका रिलेशन जरा सा मेरे को जो ध्यान में है वो दरार आना चालू किया और कुछ बातें बंद हुई इस तरह से।
Write all these things.
Sorry.
When Khushi had gone against their will and
against marriage,
When
love
she
marriage.
had married against the will of their father and mother, then the dispute arose between them and the talk between the parties stopped.
जैसे घर में आना जाना, जो रक्षाबंधन हो, भैया दूज हो या कोई भी फेस्टिवल हो, उसके पहले वो आना जाना मैं रेगुलर देखता था और सेलिब्रेट भी करता था। बट वो धीरे धीरे 18, 19, 20 के बाद वो धीरे धीरे कम होता गया। वो खुशी की तरफ से हुआ, हमको नहीं लगता कि हमारे बुआ फूफा जी की तरफ से कोई ऐसा हुआ होगा।
Before 18, 18, 19
हाँ।
Before 2018.
After 2019 समझो।
2018 or 19, I had seen her coming.
She come, yeah.
To visit my uncle and aunt. They had a good relationship, but after 19, the relationship
19 और 20 के बाद ही
19 or 20, the relationship got bitter.
उसके बाद मैंने कभी रक्षाबंधन हो या भाई दूज हो, मैं देखा नहीं खुशी को कि हमारे घर पे आती हुई, बुआ जी के घर पे आती हुई।
After that, I did not see Khushi coming to my uncle and aunt's house in Raksha Bandhan or in other occasions.
भैया दूज जो भी हिंदू का फेस्टिवल होता है उसमें।
And in all other
or any other festivals.
In the festivals.
To your knowledge, was the defendant present at the residence of the deceased on 3rd November, the day the will was executed?
जब ये will 3rd November को वहाँ execute हो रहा था, खुशी टेब्रेवाल क्या वहाँ पर present थी, उपस्थित थी?
सर जैसे मैंने पहले भी बताया आपको कि मैं 3rd नवंबर को शाम को गया था।
As I have deposed earlier that I
came in the evening of 3rd November.
On 3rd November, कौन सा साल?
2019 sir.
2019, when I went to the house of my uncle, क्या
उस
हुआ?
समय भुआ जी थे, फूफा जी थे, सुरेश टेबरीवाल जी थे, बीना टेबरीवाल थे, इंगित था, तने था.
At that time, my uncle was there, my aunt was there, Ingit was there, and
तने टेबरीवाल.
Tanay Tibrewal
और घर में फूड बनाने वाली जो रहती है वो थी. बट मैं जब शाम को गया था,
was there who used to prepare food, and in the
बट खुशी वहां पे शाम को नहीं थे.
but Khushi was not present there.
In the evening, in the evening.
In the evening.
इवनिंग टू टिल नाइट में रात देर तक था.
He was there evening till night.
My lord, the counsel who was cross-examining, he's not here today. My lord, if this can be deferred because we need a certain instructions also from the client.
That is a problem, sir. That is the problem. 16 January, the court was adjourned for cross-examination.
You have few other concluding questions.
But every time the witness cannot. That's why this court is fixing a specific date so that the witness should not be harassed by keeping aside all the matters.
My lord, one chance, my lord, very limited scope.
Correct.
Only attesting witness.
This court is fixed on 16 January. The court announced. We are on February. 2 months you got. You could not get prepared. You are not prepared for the cross examination.
My lord, because my lord, I have asked whatever, but there are few other questions.
No, I will not allow. Sorry.
My lord.
After 2 months, the case adjourned. I will not allow.
My lord, then I'll take the suggestive and conclude.
As per your wish, I am not pressing you what you have to done, but I will not allow the adjournment. Fixed matter, you know. Your lawyer should know. 16th January, he was aware the case is fixed today.
It was a grave urgency in
whatever it may be.
Could not. My lord, I'll just take the suggestives and then I'll conclude then. I suggest to you that you were not aware actually about the health and health conditions of your uncle as alleged
आप मानते हैं या नहीं मानते हैं, ऐसे आंसर को दीजिएगा पहले. ठीक है, मैं मानता हूं या नहीं मानता हूं. आपको आपके अंकल के हेल्थ के बारे में ठीक से पता नहीं कि वो कैसे है. आप मानते हैं या नहीं?
नहीं मानता हूँ, उनकी कंडीशन बहुत अच्छी थी हर तरह से.
ना उनका क्वेश्चन है कि आपने जो बोला ना कंडीशन, लेकिन उनका बोलना है कि जो आपने बोला उन कंडीशन आपको कुछ पता नहीं था, सही है कि नहीं है उनका कंडीशन के बारे में, हाँ या ना?
ये कैंसर का बीमारी है, जो भी बीमारी इसके बारे में पता था, बस क्यों आके बताए थे, उसके पहले नहीं पता था.
I knew about his ailment regarding cancer.
I suggest to you that your uncle was not in a fit and proper health condition or mental state during on the day of the alleged execution of the said will.
सर मैं ये फिर से एक बार बोलता हूँ, ये सरासर गलत है.
ठीक है, बस वो यहाँ या ना, सही है गलत है वही बोलिए. वो
बस एकदम गलत है सर.
उनका काम है पूछना आपसे हाँ या नहीं में जवाब दीजिए.
आई एम नॉट एग्री सर, एकदम गलत है. नहीं ठीक है सर.
आई
आप बोल सकते हैं कि मैं नहीं.
ने किया कुछ है फिर
नहीं ये बात
नहीं. कंटेंट के बाद न्यू मोशन आज क्या न्यू मोशन था ना, कल अर्जन मोशन अर्जन ऊपर कर अर्जन ऊपर But to be mentioned.
नेगेटिव नहीं करते.
जो भी है हम लोग अपना लिस्ट
I suggest to you. Well,
Yes.
yes. I suggest to you that your uncle was not in a proper and fit health condition, nor was in a proper mental state, as because he himself has suggested in the will that he was terminally ill.
आपके अंकल का मानसिक और शारीरिक स्थिति उस समय ठीक नहीं था, क्योंकि उन्होंने अपने विल में ये बताया है कि वो उस समय बीमार थे. आप ये मानते हैं या नहीं मानते?
बीमार थे ये ठीक है, बट मानसिक स्थिति या समझ उनको नहीं थी, ये बात गलत है. वो एकदम परफेक्ट है, फिट थे, सब कुछ समझ सकते थे. और वो जो विल कर रहे हैं, यस.
He was ill, that is true, but I do not agree that he was mentally and physically unfit.
I suggest to you your deposition on the entire health condition of your uncle is made up and not known to you.
That already first question covered.
Then my lord may close it.
That's all.
Most of the,
No further question.
my lord.
That's all.
Yes, my lord. Suggestives and my lord. I think nothing else to be covered.
Yes, आप उतर जाइए.
Thank you, sir.
It's only that one earnest prayer that we'll make. We know that your lordship is very hard pressed with time. If any short date can be given, my lord, we have
You will
another
add
witness.
this further
Yes,
evidence?
yes. One
What? Executor?
No, my lord, the propounder is there and there's an handwriting expert for which, my lord, a very short evidence is required. He has given a report on the, my lord, signature.
Report is there?
Yes. That would be a very short.
Expert of the private or the
No, private.
Mm-hmm.
The report is on record.
So appearing for the plaintiff. So appearing for the defendant. Plaintiff witness is present. Cross-examination resumed and concluded. Counsel for the plaintiff submitted. He will adduce further evidence and press for time.
Taking the cross-up.
Full stop. The plaintiff witness number 1 is discharge. Full stop. Let the matter appear on. Short date is a problem. 11th April. 11th April, 3 p.m. for witness number 2 of the examination of witness number 2 of the plaintiff and cross examination.
Deeply obliged, my lord.
And for the plaintiff, my lord, led by Mr. Gautam Chakraborty, my lord, as per instruction, my lord, I am praying for not this week, my lord.
Item number 23.
Yes, my lord.
He was pressing hard to argue the matter for interim. Now, when the matter is taken on we are praying for the time. For the last 2 weeks, is as per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 19th. Not 19, it's the non-commercial, no? 19. Next.
Matters, item number 24.
Yes, Mr. Basu.
The next matter.
I'm on
Yes.
behalf of the plaintiff.
Ah.
I pray for short passover, my lord.
Also,
125.
My lord, may I have the privilege to address on behalf of the contempt number 1? We file our affidavit, my lord.
who is for the petitioner? June 24. Readings have been completed. 24 July. Thereafter, no. No.
I believe, my lord, the other contemners also, 2 and 3, they have also filed their respective affidavits. Anyway, my lord, I only concern, my lord, of my client. I tell you, lordship, this is basically, my lord, nothing but a problem of ego.
Publication.
Yeah, my lord, my client only runs a charitable institution. Lordship may hear, my lord, name of the hospital, Anandolok, is in the Kurunamai, Salt Lake, a very renowned hospital.
Karunamai.
My lord,
Karunamai.
Karunamai. Anandolok Hospital. Here, my lord, the patients are being treated and diagnosed, my lord, at a very nominal rate. Even, my lord, high cost, my lord, operations like pacemaker bypass, those are also being done, my lord, with rupees 20,000, 30,000. And here, my lord, the case is that in order to expand, my lord, the further, my lord, the building of the hospital, a plot was identified, my lord, in Rajarhat area. And here, whenever this plaintiff initially assured that I will accommodate this particular land on a free of cost. And then, my lord, this agreement was entered into. A press meet was arranged before, my lord, in presence of His Excellency, the Governor of West Bengal. And, my lord, there it was, my lord, publicly, my lord, represented that the Anandolok Hospital will be getting this plot of land out of the, my lord, donation being given by the plaintiff. Subsequently, it happens, my lord, the area of the plots which were to be given, that was not given. A portion, the Anandolok Hospital was not required to pay anything. They were asked to pay. That is the problem started, my lord. And on the contrary, my lord, this plaintiff wanted that his name should be there.
Pressure.
And my client said that why did you commit a mischief? And my client, I said, I tell you, lordship, he is an octogenarian person. Almost he is reaching 90. If your lordship even calls him on the witness box, he is a very rigid person also. He says that I will go by the principle. I also tried to tell him that the matter is pending a defamation
Aged
thing.
person always this.
Is a old thought of school, my lord. I said, please, no, I am not doing anything disregard to the court. I only, I am telling the press what is actually, what has actually happened to me. Now, this is the situation, my lord, and
Okay, nobody is there. None appears on behalf of the plaintiff petitioner. You are appearing for respondent content number
1.
1. So appearing for the content number 1. Case adjourned. Let the matter appear on 27th March.
Okay, that's content number 2.
Content number 1 and content number 2. Yes, next.
27th March. Great.
Yes, sir.
And for the contempt, alleged contempt numbers 1 and 2, my lord.
1 and 2. Who is for the petitioner? Content number 1 to file their affidavit in opposition. Also for the petitioner press for time to file affidavit in reply. It is found from the record already been.
We have filed our
It
affidavit.
is already filed the affidavit in reply to the affidavit in opposition. Let the affidavit in reply filed to the affidavit. You file the wakalat nama?
Right.
Yes. Who is for the petitioner?
Miss.
So appearing for the alleged content number 1 and 2. None appears on behalf of the petitioner. For the interest of justice, the case is adjourned. Let the matter appear
Even
on.
the main matter has been dismissed for default, my lord.
Dismissed for default?
Even the main matter has been dismissed.
Okay, let us see. On 3rd of April.
High contempt application, my lord. Item number 27. Lord, maybe start, my lord.
My lord, this is 27 with regard to that matter, my lord. Now the receiver is there, my lord. We have acted upon everything, my lord. We are doing everything, my lord. My lord, my respectful submission is this, my lord. We have complied with your lordship's orders, subsequent orders, my lord. Let them be discharged. We have filed an affidavit with regard to the same also, my lord. And the learned receiver also filed a report. Maintenance has been done. We have deposited money before the court, my lord. And let him,
Let the hearing start.
I'm sure Mr. Bose won't leave without a hearing on the contempt. So all this, my lord, lordship has to, my lord, take a decision on the contempt. Keeps it, my lord, any day convenient to the court since Mr. Bose is.
My lord, I was only insisting, my lord. Mr. Bose is on the way and he's requested me to start the matter. So, my lord.
But only 20 minutes you will get. 20 minutes.
And I will be, my lord, seeking some time because I'm being led by Mr. Vikas Ranjan Bhattacharya. So he would like to address you, your lordship, my lord, on the contempt.
Lord, I'm insisted.
So if they want to start, my lord, otherwise, my lord, lordship keeps it any day, my lord. I will also inform my side.
I'll just start, my lord. Mr. Bose is on the way. In that event, my lord, if he cannot conclude it on this day, my lord, we'll keep it on another day and my lord, they'll make their submission.
Yes, start. No,
I will not start today because I have a leader. I will not start. My lord, I'll pray for some time because.
Lord, may I just start because Mr. Bose is. Kindly take contempt application.
He's already charged up.
No, Mr. Bose is here.
Shall we start with the contempt, my lord?
But Mr. Kaushik Banerjee has argued there is nothing. You already heard Mr. Banerjee. You missed
Possibly,
that. You missed that.
Yeah, my lord, possibly he implies.
Of the contempt proceeding.
Possibly
Simply
he
stated
implies that
they have complied with, and this court has passed a special officer. It's because they are paying the rent. There is not contempt. Now you have to give the reply to that.
Mr. Bose.
I was wondering, does that, should a rule now be issued against him? That for saying that a rule should be issued against.
Yes.
That was
Contempt CC 55.
Yes, my lord, CC 55. Your lordship will kindly first see the acts of contempt that we complain of. But I need not trouble your lordship with the basic facts, my lord. There is an order. I will just show your lordship the operative portion of the order in respect of which we complain of violation. 55. CC 55. Well, this is an order of 22nd of January 2024. Lordship will find the order at page 116. Should be the second volume of the contempt application.
Page
116. of January 2024. It was a plaintiff's interlocutory application. My lord, if your lordship kindly makes a note of the prayers in the GA application. My lord, prayer A was in respect to lift. My lord, this is a multi-storied building. The complaint was that Foursquare Assets Management, which is the defendant, my lord, they have taken control over the entire multi-storied building, including its operations, maintenance, and they are not allowing others to use common areas, including the lift services. And they are extracting money from the other occupants of the building and without having authority, they are managing the affairs of the building. They are collecting money, so this has become a business for them.
Correct.
So they have converted the building into a business, and they are taking money from everybody, and they are running, and they don't want to give it. So this was the very one of the principal cause of action in the suit.
Yes.
Now, if your lordship will kindly turn to 117 ones, but there were already orders by which a special officer was appointed, previous orders before this, for the purpose of lift and operation of lift.
Yes.
Now, my lord, kindly take once page 117, the last paragraph of 117. Because why I show this now, in the contempt proceeding, their stand is diametrically opposite of what it was when this application was being heard. Because they are now using it as a defense in the contempt proceedings. That time, this is not what they were saying. On the basis of the submissions made by them, an order is passed. So now the order has certain mandatory directions. They violate. Contempt filed. Now, once contempt is filed, now their stand, what was not their stand then, this has now become their stand. So that also is an aggravated act of contempt. Now, let kindly take once, bottom of page 117. In compliance of the order passed by this court, the special officer has convened the meeting and submitted a report before this court. In para 5 of the report is submitted that all parties present were unanimous in their consent and unconditionally agreed to formation of an association in respect of the subject premises to enable / facilitate dispute regarding the subject issue to be resolved by the common benefit to all. So this is now, on receipt of the special officer report, the counsel for the defendant number 1 denied that the defendant number 1 has not given consent and prayed for filing exception to the report filed by the special officer. So no consent to formation of association for the purpose of looking after the maintenance and running the building. Court granted liberty to defendant number 1, file exception, and defendant number 1 has filed exception. In the exception, defendant number 1 stated that the question of formation of any association with respect to the suit property at the instance of the plaintiff does not arise, as the suit property is a trust property. Now, my lord, kindly make a note. First was, I have not given consent, despite giving consent. Opposing, then they bring in another situation of trust. Even the court handled the trust issue also. And with the consent of the trust, no association can be formed. It is also stated that trust by way of a lease deed, power of attorney, authorized such and such. It is the further objection of the defendant number 1 that the plaintiffs have failed and neglected to pay any maintenance charge at cost of the building which the defendant number 1 is maintaining since October 2015. And the defendant number 1 is claiming, this claim of 154, which according to me, kindly make a note of since October 2015. Well, this claim of 154, if it is since 15, there's something called law of limitation. So it is expressly barred by laws of limitation. So this is what they keep repeating everywhere. 1,01,54 I have spent. So we will now kindly come to, on receipt of the exception to defendant number 1, this court has issued notice to the trust. Such and such appears. Then, my lord, kindly see that what does the trust say? Time to take instruction trust. Then today when the matter is called, Mr. Such and such representing the trust submitted that as per the lease deed, the power of attorney, the trust in favor of defendant number 1 in only with respect to the property leased out to the defendant number 1. A portion is leased out to them and not with respect to the total property which are in occupation of plaintiffs. Mr. Huck submits that the property of the trust should be saved and to be maintained properly. On instruction from the trustee, the trust submits that trust has no objection either for formation of the association or to appoint special officer for the purpose of maintenance. Then, Jishan Huck, advocate representing the defendant number 1, submits that the defendant number 1 is maintained by incurring expenditure. Same, my lord. But the plaintiff has not paid the amount to the defendant number 1. Defendant Mr. Such and such, representing the plaintiff, denied the claim of made by the counsel. He further submits that he has no objection if an order is passed either appointing special officer, formation of association. Considering the submissions made by the counsel for the of the trust, the court finds that the trust has no objection for formation of an association of appointments of special officer for maintenance of the suit. It is also clear that the trust has not executed power of attorney in favor of the defendant number 1 respect of the total suit property. Power of attorney and the leased property with respect to when relying is only with respect to the property leased out to the defendant number 1 only. Then, by an order dated 5th September, this court had appointed Mr. Rajiv Lal, special officer, for some other purposes, and he has completed the said work. He will continue as special officer to do the following work for the purpose of maintaining the suit property. A, shall inspect. B, if any complaint is received. Now, my lord, kindly take C. Expenditure, if any, incurred for the maintenance of the property shall be informed to the occupiers of the subject property, and the occupier shall pay the expenditures of special officer within a week. Then, kindly also, my lord, take F. So, we are on C and F.
Yes.
Plaintiffs, defendants, and occupiers shall pay maintenance charges to the special officer regularly without any delay. Well, as regards the claim of the defendant number 1, being maintenance charge, whatever. So, there is no contempt application either against the special officer, either by them or by anybody else. There is only one contempt application, which is by the plaintiff against the defendant number 1 and its directors. I have alleged violation of this order, in particular C and F. Now, my lord, kindly have a look at the acts of contempt that we complain of and why we complain of the acts. My lord, the first act of contempt that we complain of is that he has refused, despite orders of court, despite having full notice and knowledge of the order, he has deliberately and intentionally refused to pay the maintenance charges to the special officer. Now, my lord, how do I prove this, my lord? Now, kindly take that same volume 2 of where the order is there. Immediately after that order, your lordship will kindly take once page 122. Your lordship, we had already placed the previous, when he first holds meetings. I'll straight away take your lordship to the first act of contempt. 122. This, your lordship will find the minutes of the meeting of 7th of February 2024.
Yes.
Now, my lord, kindly take the participation. My lord, your lordship will see the present, where it is, there's a name on the third batch of persons are Swarumpa Kanti Das, Rahul Agarwal, representing Foursquare, such and such. And then your lordship will find, kindly come to, my lord, page 123, towards the middle of page 123, paragraph 8 of the minutes. It was confirmed by all parties that the maintenance of the premises is being done and is being undertaken by Foursquare for long, and that all maintenance income and expenditure is being paid to and incurred by Foursquare. It was noted that save and accept the maintenance charges session elevator. Then, my lord, kindly come to paragraph 10, just 2 paragraphs thereafter. Mortgage.
Yes.
My lord, kindly take para 10.
To enable the special officer comply with the direction order for the
to enable a special officer to comply with the directions of the order, the representatives are requested to provide the following information. So, well, then, when in order to invoke that how much will be paid by whom, well, this effort is undertaken by the special officer. Then, my lord, kindly come to the next minutes at page 126. So, my lord, at 122, everybody is aware. I mean, the order is passed in their presence, but I am not on that. Now, the fact that the special officer is now going to implement the order, that is also well within their knowledge. So, they cannot feign ignorance of the fact that the special officer was there to implement the order. 126. Now, let's kindly have a look at the persons who had represented the first defendant Foursquare. Rahul Agarwal, Praveen Kanodia, Arun Singh, Kaushik Banerjee advocate, Shudipta Pal advocate, represented by representing defendant number 1. All other persons were represented by 1, but they are strong, so they are represented by 5 people. So now I'll kindly have a look at 126 bottom.
But the voting power is only 1.
But Kaushik Banerjee, the heavyweight,
equal to 10.
10. Kindly see. Kindly see now, my lord, what the heavyweight says. My lord, I am sure, my lord, the heavyweight said this with instructions from the client who were also present there. Kindly take following. The last para at page 126. Following such intimation by the special officer, and intimation was received by the special officer 26 from the advocate representing Foursquare, attaching 2 documents of such and such, thereby stating inter alia that now my client want to form an association themselves without going into any dispute. All along while the order was being passed, there can't be any association. I am the association. Then that failed trust. Then trust also gave consent. And that the adjudication of 154 will not come in the way of formation of the association. This information is Foursquare replied by the special officer. Then, my lord, kindly come to, my lord, there is a, at page 127, my lord, there is an underlined portion Foursquare. Then, my lord, kindly see. Kaushik Banerjee, advocate representing Foursquare, submitted that his instructions are that, so my lord, kindly make a note of this. His instructions are, so this is not, possibly he may have thought otherwise, but he is submitting based on instructions. That his instructions representing Foursquare submitted that his instructions are that Foursquare, Square 4, shall make all endeavor to form an association within 15 days, and that his client objects that if the association is formed within 15 days or 1 month, then there is no necessity to deposit the maintenance charges in the designated account of the learned special officer. My lord, fortunately, his client, my lord, does not have neither he nor his client had the authority to modify the order. So the order has to be complied in its true letter and spirit. Now, what does he say? 15 days time frame given by him on the instruction of his client, formation of association. So he thinks it is no necessity to deposit the maintenance charges, which was a mandatory direction in terms of the order. He further submitted that his client will render full cooperation where, my lord, and take all steps to form the association and submit the outstanding dues on account of maintenance charges. So something which does not form a part of the order, his client is willing to cooperate. But mandatory direction, non-compliance. Then, my lord, kindly take, thereafter, Banerjee reiterated that his client shall make all endeavor to form association of 15 days. As far as the adjudication of 150 is concerned, details will be shared with the lens. He further states that since the dispute for forming of the association has been settled, his client has no objection to make payment deposit of the mandate into the nominated banker of the learned special at present. Mr. Banerjee submits that after making all endeavor for formation of the association.
There is no word no. His client has objection to
Yes, yes. His client has objection. Correct. Did I read no?
Yes.
Oh, I'm so sorry.
That I think you are appearing for them.
No. How could I have read no into this? I'm wondering. Because my noting also says contempt.
Okay, continue.
He further states that since the dispute for formation of the association has been settled, his client has objection to make payment.
Now, whether the association formed or not?
Well, we are. No. Special officer
My lord,
is
not yet
continued.
formed, my lord, because we have filed an application which is for modification. It's pending, my lord, till such time that is taken up, my lord. This association thing is, my lord.
Okay.
Then, my lord, this is one act of contempt. Now, my lord, kindly take the next. Now, my lord, your lordship will kindly take page 130, bottom of page 130.
Yes.
My lord, circumventing an order is equally an act of contempt. You are aware, my lord, that prayer which requires you to pay the maintenance, and whether association or no association, that has nothing to do with payment of maintenance. Court did not say. So, my lord, the order is absolutely clear. There's no ambiguity in the order. So, if there is none, you comply. Otherwise, you should have gone in appeal. No appeal, no stay. So, no impediment so far as implementation of the order is concerned. My lord, kindly take the bottom of page 130.
Yes.
Now, my lord, if your lordship will take once the first para at 130, my lord, all attempts are made to ensure that this order is not complied with. My lord, kindly see the special officer records. I have received the preceding email today from an unspecified individual in the office of Square 4. And frankly, I am unsure what to make of it. Nevertheless, the same is being responded to for the attention of Square 4. That possibly will be their only defense, Square 4 and 4th Square. Just because I keep saying 4th Square, possibly that is the only defense possibly they have here. Apart from that, I don't see any. Now, let's kindly come to the bottom of page 130. Prior to the scheduled meeting on 28th of February, I received communication from your advocate enclosing 2 documents and intimating me intimately that you are agreeable to form an association amongst yourselves without going into the dispute. That's why I have conveyed to the advocate that Justice such and such explains why I was appointed. I have expressed myself and nonetheless always makes sense. So, this is now kindly take 132. So, it has also all along been the consistent standard special officer that I have been appointed to discharge one particular duty which I am doing. You please comply. 132 is the next minute of 29th of April. Kindly come to page 133, bottom again. This is the submission of 4th Square. At 133 bottom. 4th Square. She found that one. Praveen Kanodia submitted that the formation data sought by the special officer shall be provided. Information data shall be provided, handed over to the association only when the association has been formed. He therefore expressed his inability to do so before that. So, information data sought by the special officer, he will not give. Well, there is also direction for that. He will not give. Why? Till association is formed, he will not give. Now, who has told him to form the association? There is no direction in the order of 22nd January for formation of an association.
Yes.
Then, my lord, Mr. Kaushik Banerjee, representing Square 4, handed over a copy of an order of 24th of April passed by Justice Rao in GA such and such in the matter inter alia sought for modification of the order of 22nd January, by virtue whereof the name of defendant number 9 has been deleted from the array of parties and the order of 22nd was modified to be applicable to all parties except the defendant number 1. The said order is kept on record. Mr. Banerjee, on instructions from his client, again on instructions, reiterated that the details as per sought by the special shall be provided to the association as soon as the association is formed. He further submitted that the order of 22nd January was premised on the position that the association could not be formed by the parties, but now that his client has expressed his willingness to do so, the maintenance charges would be paid to the association as and when formed. Lordship is so the maintenance charges would be paid to the said association as and when formed, wherefrom the maintenance expenses shall also be carried out. This itself, nothing remains except
Yes.
complete, but your lordship has already issued rule, so nothing but punishment. Now, what will be the punishment? That is up to your lordship. This is a clear act of contumacious violation of an order of court. End of the day, the majesty of the court has to be upheld.
Yes.
In that view of the matter, he submitted. Kindly look at the audacity. Orders are there. Special officer, one after the order, is holding meeting. 4 months have passed since the order. And now they are interpreting the order. And it's like putting the cart before. Now they are saying, I will form the association. Till the association is formed, A, I will not give any information. B, the maintenance will be paid after the association is formed. And when there's a direction directly to pay maintenance charges. That in view of the matter, he submitted that his instructions are that there is no need to deposit the maintenance charges of the special officer. And that the other party should revert on the draft of memorandum of association prepared and circulated by the client. I'm glad that I was not the special officer. Had I been the special officer, I would have come and filed the act of application for contempt. Because somebody who's this is a clear is violating one act of violation. This is a repeated act of violation.
Yes.
But somebody can say that there is a direction pursuant to an order of court not to transfer alienate. I enter into an agreement. But if I enter into multiple agreements, so each act by which you enter into each agreement is an act of violation. So there's a large piece of land. I enter into, say, an agreement for sale in violation of an order in respect of a small portion of the land. One act of violation. Despite knowing that I have already violated and there's a subsidy, I enter into 10 more agreements. So what would be the position?
Once violated, it violated.
So that repeated violation continues. I am saying that this repeated violation continues. So, my lord, a person who has...
Yes,
I am almost done. As I submitted instruction that this, but then, my lord, kindly take the next paragraph. As such, he has submitted on instructions. But this instruction, what should be framed in his chambers? I do only things on instructions. I even violate orders of court on instructions.
He was aware.
Yeah, of course.
That's why every time he has taken the
instructions. He has submitted on instruction that since the dispute for formation of the association has been settled, who has settled, he only knows. His client has objection. This time I have not read no. His client has objection to make payment deposit of maintenance charges.
Yes. So how much time will take for the Mr. Bose? Because 3 p.m. matter is there. And
I know, Melod, there is a 3 p.m. matter. I will just show from their opposition, which is effectively, in answer to the rule.
Come on.
Any day convenient.
So and so appearing for the petitioner, so and so appearing for the alleged contemnants. Counsel for the petitioner has argued at length
but due to paucity of time, hearing could not be completed. Let the matter give the date, any date. अच्छा तो उसमें चलता है ना, कंटेम्प्ट है ना, नॉन कमर्शियल में. Let the matter appear on 20 April, 20 March.
Grateful.
20 March. 20 March.
The matter was fixed for witness action. The witness is here. We would continue. Yes. Yes, the witness is.
Yes, Mr. Any matter?
Item number 29, my lord, 28 was put in.
I don't think so.
Lord, can I, my lord?
29 of the non-commercial?
Yes, my lord. It's a contempt pet.
Acha.
Yeah, for the
Lordship, we are for the petition item 29.
29.
Yes.
Ravi Seni. That
Any
date.
day, my lord, if it is convenient to your
Lordship,
lordship.
any day next week, if your lordship. Or thereafter, lordship.
26 March.
Very well, my lord, any time, my lord.
Means contempt note it will come top. Record on 29. So and so appearing for the petitioner. So and so appearing for the alleged contempt. Though the matter is listed today, but due to paucity of time, hearing could not be taken place. Accordingly, case adjourned. Let the matter appear on 26th March.
Obliged.
Under the same heading.
All yours.
Yes, where is Mr.?
He's the one who is going to continue, my lord.
Yes, where is the witness?
Yeah, Pakshit.
My lord, I'll just point out your lordship, my lord. There are, my lord, 3 suits here. 77, 78 and 79 of 2022. Now in 77 and 78, examination in chief on the last occasion was more or less concluded. But there was one aspect for which I requested the court to keep it open, and the court agreed. My lord, 2 documents, namely deeds, which were obtained, my lord, from the online portal of the registry, were marked as X. And your lordship had some suggestion as to how that is to be proven, which is an appeal task, my lord, given our departments. But, my lord, I will have an alternative argument for those documents, my lord, to be public documents. So, my lord, that your lordship will consider. If that argument is decided against me, then I will, of course, have to take the long run process.
See, it has been online. You cannot say you can say it is in public domain, but it cannot be a public document because it is the document between the 2 parties. It is
Correct.
To that. Correct.
Correct.
And if you are challenging that document,
Yes.
or you are harping upon that document, then you have to prove that document.
Correct.
For proving the document, then you have to comply with the Evidence Act.
But if I produce certified copies, then yes.
That's why I'm telling
So that-
certified copy can be taken, but it cannot be said that it is proved. Suppose you are not like this case, you are
Yes.
not having the original. You obtain the certified copy. Leave aside the website copy.
Yes, my lord.
Certified copy that can be taken on record, but the deed has to be proved. How you can prove the deed?
But if, my lord, subject to correction, my lord, if it is a public document, my lord, it has to be taken cognizance of.
Correct.
So if, my lord, and I will cite law to the effect, my lord, that if the registry is maintaining records, it amounts to, my lord, an act of the authority.
Then in that case, suppose A purchased a property, deed executed,
Yes.
mutation done.
Yes.
C has come, this property of mine, but B by fraudulently executed the deed in favor of C. Then it is the duty of the A to prove that yes, it has been rightly executed and the B has the right over the property, then the deed was executed.
So you have to prove it was rightly executed. The C has to prove no, it is not rightly executed. I am having the title. So you cannot execute the deed. So whether only because the deed has been certified copy, exhibited and mark A, B, C, whatever it may be, can you say the deed is proved?
My lord, may I just say this? There are three suits, 77, 78, and 79. This point is a common point in all three suits. My lord, today 79 examination chief hasn't even commenced. Let me, my lord, finish that. To the exception of this point, my lord, there's less time today. And my lord, kindly give me 10 minutes on any day to try and convince the court, my lord.
Continue.
Very well. My lord, no. So it has to resume. My lord, so 79, CS 79, my lord. May I, my lord, file my...
The earlier evidence has recorded in which case?
77 and 78. And it was kept open for this point.
Now, so 79 it is leading.
79 will also reach the same stage. Then all three can be, my lord, closed on Monday with this 10 minutes of argument.
CS 79, huh? Examination in chief of the PW1.
Yes. My lord, may I tender?
Not resume. Give the oath and start.
Yes, commencement. Sorry, commencement, not resumption.
I
I
solemnly affirm that
solemnly affirm that
in whatever
in whatever
I will depose
I will depose
by way of evidence
by way of
in
evidence
this suit,
I
I
shall
speak the truth
speak the truth
and no part of it
and no part of
shall
it
be false.
shall be false,
I shall not conceal anything.
and I shall not conceal anything.
Your name, sir.
Anil Agarwal. ANIL Anil Agarwal. Yeah.
Father's name,
Om Prakash Agarwal.
age,
52.
occupation,
Business.
residential address.
21/3 SN Chatterjee Road, Calcutta.
S.N. Chatterjee Road,
Calcutta 38.
Yes,
Please show him the affidavit of evidence, please. What is this document?
This is my affidavit for evidence.
Who has prepared this document?
My advocate on my instruction.
Who has signed this document?
I have signed it.
On which page does your signature appear?
It's on the 14th page.
When did you affirm it?
Today.
What is the date on which you affirmed your
17th
the
January
document?
2025.
17th?
January 2025. 2025.
17 January 2025.
What do you have to say about the contents of this document?
It's true and correct.
Shown pages.
Who is father? Nobody.
Shown pages 1 to 21
undefended
of the judge's brief of documents. Judge's brief, just volume 1 and last volume, first and last volume. That's all.
Yes.
Yes. What is this document?
These are the bank statements downloaded from the official website of United Bank of India.
What does this bank statement show?
The bank statement shows the payment made by my company to Uttam Chatterjee.
Uttam Chatterjee.
And the page.
Please. What do you have to say about the contents of these documents?
It's true and correct.
True and correct.
And page 1 is the ledger synopsis of all the bank statement.
Wait. And page 1 is ledger synopsis of all. I will tender a 65B. Let this be marked as an exhibit.
Exhibit
A.
Is the continuation, है ना? Continuation. क्या अलग-अलग?
New, my lord.
No. एक ही बैंक का all statements are from one bank.
Yes. It's one. The summary along with the statement. Shown pages 22 to 1224. 1224. পুরোটাই দিয়ে দিন।
1224. Yes.
Just rush through it. Just for the sake of it, skim through.
Yes, what?
What is this? What is this document across these pages?
These are the copies of agreement for sale.
Yes.
Registered in different dates and with different date numbers.
Registered in different dates and different
Yeah.
numbers.
Downloaded from the official website of the Director of Registrations Revenue.
What do these? Why have you relied upon these agreements?
Because these are the properties that he have purchased using my money paid by me.
My money paid by me.
What do you mean by he? Whom do you mean by inverted commas he?
Uttam Kumar Chatterjee.
Whom has Uttam Kumar Chatterjee entered into these agreements with?
It's with Somnath Bhattacharya. Soman Chakraborty. Sorry. Soman Chakraborty.
These documents, my lord, may be
X for identification.
on page 1225.
One, two, three.
1225. Volume 9. Volume 9.
Yes, next.
Yes, what is this document?
This is the complaint filed by me about loss of my checkbook, bag containing a checkbook of all my. Please repeat, sir.
This is the complaint lodged by me for loss of my bag containing checkbooks
of different companies with different banks. And
yes.
And there is 2 specific check numbers which we can recognize instantly.
This complaint has been made before whom?
To the new officer in charge, Neolipur Police Station.
और आदमी का बुलाओ जाएगा तो 3-20.
Who has signed this complaint?
I have signed it.
What do you have to say about the contents of this complaint?
True and correct.
This may be marked. My lord.
Exhibit
B.
Shown pages 1226 to 1238.
How many documents are there?
My lord, I will just finish. two which will be exhibited, and one which will be marked for identification.
Yes, next.
Yes,
Because
yes.
1 minute is there only.
Yes, my lord. We have to go for the beloved judges farewell. 1226 to 1238. What is this document?
These are the notice sent by my office to Uttam Chatterjee for my outstanding dues. And
Outstanding dues.
Who has signed this?
my staff, Priyapal, has signed it.
Priyapal has signed this.
How do you recognize her signature?
Because I know this is her signature.
I know her signature.
What do you have to say about the?
This is true and correct.
On whose instructions was this document made?
On my behalf, on my instructions.
This may be marked as an exhibit.
Exhibit C.
The answer may overlap the question.
Shown page 139, 140.
Okay, close.
Very well, my lord. Very well. Grateful, my lord. My lord, can all three suits, my lord, be kept on a
Suffering for the plaintiff. Plaintiff witness is present. Examination in chief in connection with CS 79. Na? Started, but due to paucity of time, examination in chief could not be completed. During his evidence, 3 documents were marked as exhibit A, B, and C. Examination in chief is deferred. Let the matter appear on 1st May 2025 at 3 p.m.
My lord, and the other two matters can also, my lord,
No.
adjourn.
My lord, mention a matter, my lord, for extension, my lord.
Give fast. What? Where are you?
Let us go now.
Which number?
My lord, item number 97 of monthly list, my lord.
So suffering for the petitioner, plaintiff. He submitted the interim order granted is going to expire today and paid for extension of interim order. In view of the submission made by the counsel for the interim order is extended till non-commercial.
Non-commercial, my lord.
Till 10th of April 2025 or until further order.